Yes.
Yes.
Hmm.
So I am mentioning for listing one IA lottery. After 2 months. So, IA has been numbered.
You mentioned it before, court number 4. Whoever is taking up the main bench, I'm a secondary bench I'm taking.
Lordship, judgment has been passed by the Lordship. Sir.
Huh?
There is some small mistake in this judgment passed by Lordship.
Okay, correction.
Hello.
Today?
Uh,
We'll have it today.
tomorrow. No, with the consular petitioner, man. It's item 22. They will list after a long time. I need to get the instruction.
Okay. This is the matter of the 6 weeks. Yes.
Look, item 43. Milord, in this case, Milord, the respondent number 5 has also filed a review application and your lordship has fixed it on 9th of January. So this matter may be taken with it.
Which matter is this?
Milord?
Review against what?
Review, Milord. Order against 4123.
I passed.
Yes, Milord. Same order has been challenged by the respondent number 5.
Yesterday?
Uh,
This matter pertains to what?
Milord, promotion.
How to firm?
Milord?
From?
Promotion from the junior assistant to senior.
Oh, that matter. Pertaining to the finance department. Okay. But here we have to issue notice. How can a review be taken without issuing notice? Then let the matter be read.
No, Milord, in that case also, Milord, review has not been, notice has not been issued. Perhaps, I have checked.
Mr. Sahu, don't make a mention without knowing it. I have
Milord,
issued notice.
Let it be there on the day it should be done. Milord. On the day it should be done.
This is the matter on 9/1/2024 along with
review application 28 of the
review application number 28.
8 of 2020.
Yes.
I beg to mention item number 31. I am for respondent number 5 that they have taken perfect. We need to file an affidavit in opposition.
Respondent number 5.
Not,
At the request of the learned counsel for the petitioner, matter stands adjourned. For the respondent number 5, matters stands adjourned to be listed after 6 weeks.
With regard to item number 35, we have filed an additional affidavit today. Can it be in the month of January?
Huh?
The matter?
Okay. At the request of the learned counsel for the petitioner, matter stands adjourned to be listed after 6 weeks.
And item number 18, that is 2015 matter, where I'll have to reconstruct the file matter. That is,
Sorry. 2015 matter.
yes, madam. Or I do not have the.
The only manner in which you can mention is that you want to withdraw the petition. Very well. Otherwise, no. Don't mention of 2015. It doesn't look nice.
I'm sorry, Your Lord.
I can't help you, Mr. Counsel. 2015 matter, I would not permit a mentioning to be done in this manner, and then thereafter the people would say the 2015 matters are just going out. 2021, I have accommodated you. Kindly appreciate this thing that 2015 matter cannot be accommodated in the manner by which you are asking for mentioning. You have to have the gravest of grave reasons for the purpose of mentioning this.
My lord, I would like to mention item number 7 and 16 on behalf of Advocate D. Goods. She is out of station.
7
and 16.
16. 16 not possible. 7, you want to mention after 6 weeks?
Yeah.
7, at the request of the learned counsel for the petitioner, matter stands adjourned to be listed after 6 weeks.
Item number 16, consent has been taken for other party also.
I am not concerned with the consent. I'm telling you, somebody has to either die or the judge has to die then only you can get an adjournment of a 2015 matter before this.
Learned, I have not been,
You are not there for others.
no, I am not an engaged counsel.
Huh?
I'm not an engaged counsel for item number 16. The engaged counsel, the deputy goes, they are out.
I'm not concerned. And you are mentioning about 7.
Yes.
7 will take it up after some time because it is connected with some other petitions. Let us look into that. But what orders are required to be made?
Yep.
Don't make a mention in this.
Yeah, please, Lord.
Yes.
Impugn order is at page 10, my lord.
What is this?
My lord, retired officer, my lord. I have not been paid their pension amount, my lord. Their high pension, my lord.
Yes. Then what up?
Thereafter, my lord, I have submitted a representation at page 12.
What is there to represent? Yes.
This is the representation, my lord, I have submitted.
Then
They are, my lord, now sitting over it, my lord.
Huh?
They are now, my lord, they have not, my lord, answered any, my lord, answer to my representation.
so
My lord, I
Ah,
am not getting my pension, my lord.
you are not getting your pension for that. You file a writ petition for a pension. How do you file a contempt case against that? Is there any direction to pay you the pension?
No, my lord.
Is there any direction that to give you the service benefits? No. So you are therefore to require to file a pension against this. You have to file a writ petition.
I have 36,
Huh?
I have 36.
Yeah. Mr. Triple S Rahman, the learned counsel appearing on behalf of the petitioner, submits that instead of submits that in view of the fact that the order dated 21/12/2022 passed in WPC number 6781/2021 does not relate to grant of pensionary benefits to the petitioner, the petitioner be permitted to withdraw the instant petition, instant contempt application. He, however, submits that the withdrawal of the instant contempt application should not prejudice the petitioner to avail such remedy is available under law for the purpose of grant of his pension. Taking into account the above, the instant contempt application stands closed on withdrawal. Liberty, however, is there for the petitioner to agitate his grievances as regards pension before the appropriate forum.
At number 2.
Yeah. But this is a contempt petition. Yeah. This is a contempt petition, your lord.
For what?
There is willful, deliberate, and violation order dated 28/07/2023. Passing WPC number 1277/2023. And lordship operated part at page 10, your lord.
We have not received the money?
No, lord.
Who was appearing here?
Lordship notice is motion. So notice maybe.
Yes, Mr. H. Sharma. Give him a copy of the contempt application.
No, Lordship. Sorry, Lordship. In the contempt cases, Lordship, it's a
Notice
No,
once.
no, it is not there. Give him a copy of the contempt application.
Once I was humiliated, but because of that, Lordship, I did not want.
No, not because of that. I should take up the matter with Mr. S. Borua, who was appearing. Why I should not draw contempt against Mr. S. Borua, the law counsel?
Lordship,
He had made a statement out here before the court that the amount of rupees 2 lakhs have already been disbursed and would be thereupon disbursed to the petitioner's bank account bearing number so and so.
Right.
And now the payment has not been made. And it is on that count this court had closed the said contempt application. Call Mr. Esburua when I'll take up the matter after some time. He has to take up with the instruction with that particular person.
Lordship.
This is not done. This is taking this court for a ride.
Yes, Lordship.
I closed
The
the
amount of
I
has already
closed
been
this court.
sanctioned.
Yeah. Because he
Lordship,
said that the
let me-
amount would be disbursed to the petitioner's
Lord-
account within 15 days, and therefore this direction was given. So ask Mr. Esburua to be prepared.
Lord,
And which was the department?
Revenue department.
Huh?
Revenue.
No, payment has been made. Who was the department who is going to
Disbursement.
release it? District Commissioner Golaghat. And Mr. Sharma, you
Sir.
kindly inquire with the District Commissioner Golaghat. I'll take it up the matter too,
Lordship.
as to why this amount, because there is a categorical undertaking given before this court.
Lordship.
Take it up.
Lordship, at two, Lordship.
You'll get the money by in the evening.
At number 3.
Lordship, item number 3 also same.
Same?
Yes, Lordship, but that is in order, Lordship. Operative part space 11, your Lordship. Their Lordship directed that the amount will be disbursed within 2 months, Lordship, after due inquiry.
No. This is not same.
Not same, but there is.
Mr. Counsel, then don't like to take this thing. This is not the same like other one. The
Yes.
other one, he was saying that the amount is going to be disbursed within 15 days.
Yes, Lordship.
And I would be disbursed very soon. I gave them 15 days to do that.
Yes.
Here there was a question out here. We will look into it.
Different matter, but
Yeah,
after
the
due
question of
verification,
inquiries also.
Yes.
Entire exercise be completed. Yes, show me when it was received by them.
Lordship, order passed in 1707/2003. In order, your Lordship, Honorable Court directed the respondent after verify if the indebted, then they will disburse the amount as per the notification in the account of the respecting of the deceased.
Hmm.
Lord.
Then
Lordship, we communicated through an application at best, your Lordship.
what stopped you from communicating it in a proper manner?
Yes, Lordship.
Huh?
Lordship.
How do you know that the communication was duly received by them?
Lordship, the communication application and certified copy order has been through a registered copy of Lordship.
No. Has it been received?
Yes, Lordship.
How do you know?
Through online process.
So
track
you have to
consultant.
enclose. First of all, what stopped you to give it out there by hand? What is wrong with you? Why have you sent it by postal receipt? All these things happen because of this. Service not complete properly. From the materials on record, it does not reflect that the service has been duly effected upon the contemners, upon the respondents. The learned counsel for the petitioner seeks for 2 weeks' time for filing an additional affidavit bringing on record the documents to show that the service was duly effected upon the respondents concerned. This is the matter, court.
4 also same here.
Same way with which one? 2 or 4?
4 here. 4.
That is why courts are not passing orders against you. Why you have not done this? And you have not given here to the deputy commissioner.
No, Lord.
Why?
I directed on the respondent number 1. That's why.
Hmm?
In order, Lordship directed.
2
on the
months from the date
respondent
a certified copy of the is served. So how did you have to go and give it? Same order upon the respondent. One respondent here.
Sold it.
Huh?
Sold it. Item number 5, sold respondent. 4 sold respondent, and item number 3, 2 respondent.
None appears on behalf of the petitioner on petitioner on call. List the matter of the 2 weeks.
6.
None appears on behalf of the applicant on petitioner on call. List the matter of the 2 weeks.
My lord, so far the item number 7 is concerned. 8 is concerned, my lord, it is already, I have filed another writ petition, that is item number 9. So in view of the subsequent writ petition, the first one is, my lord, it is infractuous.
Hmm?
First one is infractuous, my lord.
Which one?
8.
It has become infractious.
My lord,
Hey,
the-
put it. Mr. P. Mohantola, Relevant Counsel appearing on behalf of the petitioner in WPC number 722 oblique 2023 submits that the said writ petition has become infractious. Taking into account the above, the said writ petition therefore stands closed as it has become infractious. Interim order was there.
There is no interim order, my lord. There a fact is that, my lord, so far there are 2 relief I thought, my lord.
Hmm.
One, my lord, that we may be allowed to harvest the crops. And
Oh, that one.
yes, my lord. And second one, my lord, regarding the matter compensation. This property, my lord, the crop was allowed by the honorable court. If it is 10, that to be allowed to be.
Matter came up before division bench.
Division bench. The division bench stated that this is, I admit that this is already under submerged on the water, so but there is nothing remain. So, my lord, so far the compensation parties, it is keeping open, my lord. So
Where?
I am on, my lord.
Which one?
This is 9, my lord.
So eight, and what is this IA for?
That was filed in IA, my lord. Regarding, my lord, the subsequent certain developments were there because in spite of the order passed by the honorable court not to destroy the standing crop, that was destroyed. That is why, my lord, we filed a petition for remaining crops to be, my lord.
So IA also has become infractious.
Yes.
IA also
But the second, my lord,
goes.
9.
Now
petition,
come to 9.
the
Then
9,
what
my
is
lord,
A? What is 7?
7, my lord, is other.
Yeah, 7. What is it?
Is out of exception.
So what?
Sometimes.
Yes, what is it?
Lordship, Counsel D. Gogoi will appear in this matter. He's on leg. Lordship may kindly take it for consideration.
Okay, 7. Segregate. 8 is withdrawn. When infractious closed. 7. The counsel appearing on behalf of the petitioner seeks for an adjournment of the matter to list the matter of the 4 weeks. All segregated, huh?
9 also.
9 now. 8 to do.
My lord, so far 9 is concerned, they have filed the affidavit. So my prayer is, my lord, is at this stage, my lord, the petition may be issued, my lord, that may be take to the petition. My
Okay, now let us go for 9. What is this matter about?
matter, my lord, remaining, that is, I have already stated, my lord, is only the compensation part, because the, my lord, they have issued the, my lord, the eviction notice prior to the final order that is been passed by the speaking order, that is annexed 19 at page 82 of my writ petition. So that should be, my submission was that should be first come, then, my lord, the eviction notice should have been issued. But they issued the eviction notice prior to speaking.
Yeah, notice has not been issued.
That is, the notice not been issued. That is why I paid the notice.
So long orders.
Only they were allowed to, my lord, to file the file a affidavit. That is why they have filed the affidavit. Detailed affidavit they have filed.
Notice has been issued. Notice has been issued on 27/4/2023.
Then that matter wrongly listed, my lord.
Hmm?
Then matter wrongly listed as a motion.
No, actually it needs to be segregated with that. Here, the petitioner is not, doesn't want this matter to be taken up. There was 722.
7.
No, 785. They are not interested with the matter. So we segregate that. Huh?
Follow, my lord.
So now what remains in this?
My lord, only the compensation part, my lord, I paid, my lord, it is all are there. my
What
lord,
compensation?
My lord,
What compensation?
my lord, whatever damage they have caused to me, my lord.
How do this court assume?
My lord, it is not court by, but that to be assessed by the department concerned.
So go there. Have you asked them for the compensation?
Revenue department, that can be assessed.
Have you asked them for the compensation?
In the writ petition, my lord, is a subsequent.
Writ petition is before the court, not before the authorities.
That is
Now, Mr.
Mohan.
Monto, kindly tell me, have you asked for the compensation?
That is right now I have not filed, but the
Go, go, you are, I'm giving you the liberty, go there
Then,
and
all
ask
right,
for
all
that
right, all right.
compensation, whatever you want, you
But-
can very
but-
well ask.
but-
Because that has to be assessed. You may also file a suit, whatever maybe you do.
Yeah,
But
lordship,
how can this court
yes, sir,
assess the
lordship,
compensation?
I fully oblige your lordship. But one thing, my lord, my prayer is this, my lord. So far, they have violated the provisions of the, my lord, is section 26A of the Wildlife Protection Act, because they have, without declaring the proper land that to be declared as a sanctuary completely, my lord, they have issued the notice prior to that, 1 month before. So this is almost, my lord, they're putting the, my lord, cart before the horse like that, my lord, this thing. So I prayed, my lord, this act of the, my lord, the forest authority is totally illegal and totally, my lord, in violation of that provision, my lord. They have demolishes my all forest, my lord, is agricultural product. That was, my lord, more than 100 bighas of lands were there. All crops were destroyed. That should not be done by the state at this, my lord. This is ultimately a national product, my lord. GDP, my lord. That GDP they have also destroyed.
So, but Mr. Mohanto,
Yes, my lord.
the question which remains out here is, your harvest has already been destroyed. There was water. If I remember, the matter came up before the division bench.
Yes.
Then the next thing is, you want compensation. Now, if there is an infraction to the provisions for which you will be entitled to compensation, otherwise it would not be. Now, would it be proper on the part of this court to deal into that aspect of the matter now?
Lordship will pass any order, my lord. Lordship, I want to, my lord, place even to order pass. This was the only that all highlight thing on that thing, my lord.
What?
This was the while this my writ petition was disposed of. Last part of it.
Appropriate forum. So therefore, in view of the division bench judgment, in fact, this needs to be closed.
Appropriate forum means, my lord,
It can't be before this court.
Lordship is the appropriate forum, my lord. Lordship can pass any order.
It will be very difficult. No, in fact, it will be very difficult. That day I was dealing with another matter wherein the question of facts are involved. Once the question of facts are involved, it becomes very difficult for this court to deal with. Yes, if it is a constitutional thought,
Yes.
This court can only impose
Yes,
a
yes.
very limited, but it would not recompense what you have lost.
Yes, ma'am. So, my lord, Lordship may dispose of the direction to the competent authority, but I pray that.
What for direction for what?
My lord, I will file a.
You know, if you want a claim anything, file it, any proceedings which is permissible, not this court. You can't ask for compensation before this court, or you are asking for 50 lakhs. How do I
No,
assess?
I am not asking for any amount, my lord.
You
I-
have stated
My
prayer.
prayer is, my lord,
Kindly
Lordship
see the
can
prayer.
direction to the.
No, kindly see the prayer.
Yes, yes.
Page 32. The crops of the petition approximately of a value of 50 lakh.
That is my claim, my lord.
I know, but on what basis would this court adjudicate that?
No,
How much it
I
is?
am not praying that to highlight anything on that, my lord.
My prayer is to, my lord, to competent authority to decide my claim if I file the application for compensation.
Have you filed your
Yes.
application?
And my lord, one thing, my lord, only. my
No,
lord,
but Mr. Monto, have you filed any
till
application
today-
for
till
compensation?
today I have not filed, my lord.
Then
Only
within
Lord-
that
Lordship
amount
can-
to, because the moment I give you, I create a right upon you for moving them and thereupon giving you again a right to come back to me.
No, I am not right. Lordship can pass an appropriate deed jurisdiction, my lord. The Lordship can pass any order, my lord. This is a read is a very large, my lord. Is a very big things, my lord. It is not to be confined in a particular.
They can also pass an order, give them 10 rupees.
My lord.
You see, the question is how would this court come to a finding? The moment I give them, just for example, I give them 10 lakh rupees. No, Mr. Mahonto, kindly appreciate.
My lord.
I give him 10 lakh. What is the basis? Am I in a position to go there and find out how much is the loss? How much was the price of the seeds? How much you would have earned on the basis of that? How much would have been the sale price? And how much profit you would have made? These are questions of facts
Facts
which
and
needs to be
circumstances.
adjudicated before a proper forum.
That is, I paid, my lord.
We go there.
Let Lordship at least give this my liberty so that I can approach with all the grievances, and they will, my lord, consider if I.
Absolutely no. That is your, if you want, you can go very well. But this court cannot, because the moment I give them, you ask them to consider. And if they reject, what happens?
No.
You come back to me.
No, my lord, one sufficient, my lord.
You can't come back,
One, my lord,
back to
my-
this
one
court.
suffi- One, my sufficient, my lord. Everything was happened while the, my lord, writ petition first one and second was, my lord, in.
Okay. Let me now dispose it.
That is the only my prayer. It is
Therefore,
not that the- after the filing.
The
of this-
instant writ petition has been filed challenging the order dated 9/3/2023 passed by the respondent number 2, whereby the prayer of the petitioner to harvest the remaining crops from the land was rejected, as well as for sufficient compensation to the members of the petitioner society on the ground of demolishing their dwelling houses and standing orchard and other valuable trees which the petitioners reasonably assess to be assessed at rupees 50 lakhs. Full stop. It appears from the records that by the detailed order dated (27/4/2023), the coordinate bench of this court had issued notice However, no interim order was passed taking into account the preliminary objection raised to the maintainability of the writ petition, inasmuch as the petitioner society is not a registered society. Further to that, this court had also rejected the interim directions to harvest the crops full stop. The petitioner thereupon, being aggrieved, approached the division bench of this court in writ appeal number 206/2023. Pusto. When the matter was initially taken up by the division bench of the court, Mr. Monto, who was directed to intimate as to what is the present position, that this is the second order. The first order was?
First order was pilot today, DFO minor, concern minor pilot.
No, there was a direction to the, when the matter was taken up by the division bench, a direction was issued to the concerned respondent authorities to intimate as to what was the present status of the crops in question. Pusto. Thereupon, when the matter was listed before this court, before the division bench, on 27/6/2023, it was duly intimated to the court that that the entire crops were destroyed due of the floods, water. And it is under such circumstances, the writ appeal was closed, giving the liberty to the petitioner to approach the appropriate forum for the purpose of compensation. Today, when the matter has been taken up by this court, the question arose as to whether this court can adjudicate as regards the factum of compensation. It is the opinion of this court that for adjudicating the question, the factum of compensation, various aspects of the matter would require to be taken into account. That is, the investments so made by the petitioners, the loss which has occasioned to the petitioner, and the profit if the petitioner would have made out of the standing crops. All these aspects are questions of facts which would require a detailed examination on the basis of evidence. It is the opinion of this court that such intricate details as regards evidence, intricate adjudication of the facts would not be permissible under Article 226 of the Constitution. Be that as it may, this court, however, observed that if the petitioners are aggrieved by the actions of the respondent authorities, or there is any violation to the and if there is any violation to the rights of the petitioner would be well advised to approach the appropriate forum wherein the adjudication of facts would be permissible. Accordingly, this court, therefore, is not inclined to issue any writ as has been sought for in the instant petition. However, the liberty is given to the petitioner to approach the appropriate forum wherein the facts as regards the question of compensation can be adjudicated.
One part, the property is unregistered and also is the unregistered society. Petitioner society is a registered minor.
He said, I never said that. I never said.
So for item number 6, I could not make it, my lord. The lordship has fixed it after 2 weeks. My lord.
Yes.
May I pray for, my lord, day after tomorrow? My lord.
Why?
Some urgency is there, my lord.
So, contempt urgency.
My lord.
What is the urgency?
There was a direction to the chairman of the municipal, my lord, corporation to, my lord, consider the grievance that the neighbor, my lord, is constructing an illegal construction, causing damage to the, my lord, residential building of the present petitioner.
What is the urgency?
My lord,
You want an interim order?
no, my lord.
Then?
At least notice, my lord.
Notice, how is it urgent?
My lord, because, my lord, chairman is not considering the, my lord, application of the, they even did not.
Let us see what is the order passed.
My lord.
Yes.
That is, my lord, 11, my lord, it starts.
Yes, what is the direction?
Direction lordship will find, my lord, that is 12, my lord. The office of the chairman.
So,
So, my lord, the office of the chairman did not even, my lord, accept this copy of this order. So we have to, my lord, send it to registered post. They have received it, my lord. I have submitted the acknowledgement postal tracking report also. But they have not, my lord, looked into the matter. They did not even call the, my lord, the respondent who is my lord, going with, my lord, illegal construction, causing damage to my residential building.
so why you're not taking an injunction?
My lord, that I have suggested, my lord.
Then
But there is an
they
order,
want
my lord.
the help of the court.
Yes, my lord. There is an order, my lord.
But
Consider,
Mr. Kulta, you know, these are better for to go before the injunction.
my lord,
It's absolutely a private dispute
my lord.
between you and the respondent number 3,
Correct.
wherein it has been categorically mentioned that the respondent number 3 should, if there is a construction made by them and he is constructing upon your land, then why are you not getting an
Not in
injunction?
my land, my lord. They did not keep, my lord,
The setback.
Yeah.
Very well, go there, get
my
an
lord,
injunction.
there is a violation of the, my lord, building, my lord, permission. That is why, my lord, this honorable court has please direct the chairman.
The court has only, you are saying the violation of the building permission.
Yes, ma'am.
What did the court direct? That if there is
Examine, ma'am.
no, the court direct that if there is an NOC, put your hands away. Isn't it? That is what the
Yes.
direction kindly see. It is made clear if it is found that a construction without proper authorization or NOC for the municipal road, only in that event the response number
The
3.
proper
So,
authorization, my lord.
proper authorization, there is an approval PAM. You say that but he is constructing on your setback.
Yeah.
Go there before the trial court. Get an injunction. Where is it?
My lord, I have suggested, but my lord, whether, my lord,
But they want only the help of Mr. N.K. Kulta.
no, my lord, no, my lord, that is,
And
my lord,
N.K. Kulta does not go to the trial court. Something like that.
no, my lord, it is,
Then-
my lord,
Huh?
I cannot help because, my lord, they are in, my lord, from Hojai, my lord. That is why I have the. I
That
cannot
is why.
suggest, my lord.
That is why they want exclusive expertise of Mr. N.K. Kulta.
My lord, that is,
And he does not want to go to Hosai.
my lord, that is,
Hosai, there is a good court. Go there.
my lord, that is not true.
Get an injunction. Huh? Weather is also nice. Go there.
I am praying only for, my lord, notice so that, my lord, chairman, my lord,
Notice this court.
examine the, my lord, NOC, whether it is violated or not.
So, Mr. Kulta, issuance of a notice is not such an easy thing out here in a contempt matter. This court
Otherwise,
will
my lord,
definitely aid you. But here is a case where the order is case that it is only when there is no NOC authorized permission, then only you have to look in, otherwise not. Then how am I going to be satisfied now that whether there is a yeah or not? It is a question, purely a question out there for you to get an injunction.
that is true, my lord.
Or should it come after vacation? What do you say? Huh? Because you see, because of that order, whatever it is, issuance of a notice out here would have far-reaching consequences. You see, first the order passed in the motion stage without hearing the response number 3. So it is the court is not aware as to whether there was an infraction of any permission or not. And court said only that it is a private dispute between you and the respondent number 3. The penultimate page of the order, the last paragraph. Please.
Yes.
You will be well advised to move an injunction.
Close it, that giving him, okay.
The instant contempt application has been filed by the petitioner alleging violation of the order dated 13/10/2023 by the chairman of the Lamding Municipal Board. A perusal of the said order dated 13/10/2023 passed in WPC number 6060/2023 reflects that this court had taken into consideration that the dispute between the petitioner and the respondent number 3 in the writ proceeding was a private dispute.
Or 6.
Respondent number 3.
Response is the chairman, my lord. Respondent number
A
6 is
dispute between petitioner and the respondent number 3, it has been made.
6 is the private.
Okay, petitioner and the private respondent therein was a private dispute pertaining to immovable property. And ordinarily such disputes should be resolved before the civil court. However, this court, taking into consideration the submission made to the effect that if a construction has been carried out without permission, the Lamding Municipal Board would have the authority to look into the same. It was also made it very clear that if the construction is made with proper authorization or NOC from the municipal board, then the respondent number, yeah, the entire order, that is the mistake which has happened. How do you clarify this? Because respondent number 3, it has been mentioned, it should have been respondent number 6. The municipal board would intervene in the matter, would not intervene in the matter. And in such regards, the dispute has to be adjudicated by the civil court. Pursuant to the said order, the petitioner submitted a copy of the said order to the chairman, Lamding Municipal Board, on 17/10/2023, alleging that the private respondent in the petition have been carrying out certain construction certain unauthorized construction in violation of the construction permission, and as such sought for initiation of corrective measures. The same having not been done, the petitioner therefore has approached this court by filing the petition by instant contempt application. This court, upon hearing the learned counsel for the petitioner, is of the opinion that this is not a fit case for issuance of notice for the reasons assigned hereunder. First, the order dated 13/10/2023 passed in WPC number 6060/2023 as it stands directs the respondent number 3 to intervene if and only if the construction was carried out without authorization or NOC from the municipal board. And it was also mandated that if the dispute is outside the ambit of the construction permission oblique the NOC, then the dispute would have to be adjudicated by the civil court. From a perusal of the communication, dated 17/10/2023, it reveals that the dispute in question is not a dispute pertaining to raising of construction without the construction permission oblique the NOC. But the dispute revolves around as regards construction be carried out beyond the permission. As alleged. In the opinion of this court, therefore, taking into account the directions passed by this court on 13/10/2023, the respondent municipal authority taking into account the above, this court, the respondent municipal authority could not have therefore entered into the dispute, private dispute between the petitioner and the respondent number 6, namely in the writ petition. And the same, therefore, has to be adjudicated before a civil court. Under such circumstances, therefore, this court finds no reason for issuance of a contempt, as prima facie there is no willful or deliberate violation by the respondent number, by the sole respondent. It is under such circumstances the instant contempt application therefore stands closed. However, liberty is given to the petitioner to approach the civil court for redressal of his grievances. However, the petitioner would be at liberty to approach the civil court for redressal.
Number 10 to 12.
There are 3 writ petitions.
In
item number 11 and 12, notice has been issued. We have filed our affidavit. With respect
Why are these matters before? These are for motion.
Lordship, item 10 notice was not issued. In item number 10, notice has not been issued.
10.
Lordship,
What is this type of, what matters are these?
Lordship, in this case, they have challenged the final order passed by the authority service sector.
Authority?
Lordship, GST authorities passed order, final order, executing their demand and suppose notice. In item number 11 and 12, they challenge the demand and suppose notice.
Then why should this court entertain this type of petition? There is no appeal.
provision of appeal is there, Lord.
Yes.
We need to
And kindly don't make the submission that your senior is not around. This type of submission, this court doesn't hear.
Lordship, we need to file a reply in item number in this case.
Forget about reply. First tell me, why shouldn't I dismiss your petition? The first. Reply we will. You see, if I look into their petition, affidavit, then only the question will come up, their reply. I would not. Now tell me, you satisfy me as to why you should not, this court should at all issue notice in this type of matters.
Lordship, Thane department has issued demand notice, which timbered year. That pertains to 16 and 17 assessment year, and the notice has been received in the year 2022, way beyond the period of limitation. And although we are court, your lordship, we are not applying any goods or services.
Huh?
Yes, sir.
You are closed?
We are court, your lordship. We are regulatory commission, and we are not supplying goods or services.
So they hold it that you are doing service.
This doesn't fall under the definition of court, Lordship. This is our.
Hmm?
The electricity regulatory commission is not a code as submitted by the petitioner. They are involved under the service tax or service tax and the Finance Act 1990.
This commission is made under what provision?
Lordship, there is a regulatory provision is there.
Is it an adjudicatory body?
This is a question of dispute. Lordship.
It is not a question of dispute, it is a question of law. On the disputes being created by both of you. But his two grounds is it's beyond limitation.
Yes.
And the second is as regards this Assam Electricity Regulatory Commission does not discharge, does not provide any supply of goods or service, and as such GST would not come in. But what do you, why, did you apply for resolution of the dispute? There is a forum there where this aspect can be very well taken over. Why have you approached this court for that issue as to whether they will come within the ambit? There is a particular mechanism in the GST where a person can very well go out there that whether this service will come within the ambit of supply or supply of
There
service.
is a provision for advance ruling. Lord.
Where
They
is
can
that?
approach the
Why they have not gone?
They have not gone.
Isn't it, Mr. Counsel? You were supposed to go for the advanced ruling thing.
In Finance Act 1994, this provision is also there.
Huh?
In Finance Act 1994, this provision is there for advance.
Here also,
Yes, here also.
you have the advanced ruling.
Yes, in
You can
Unauthorized.
ask for that. Why haven't you approached the authority? Or is it, Guwahati High Court is nearer. In which case notice has not been issued.
Lordship, in item number 11 and 12, notice has been issued. They approach this honorable court, immediately to stay the notification till returnable date. And we file our affidavit. But in item number 10, Lordship, the final order has been passed.
Oh, here this 4842 notice has been issued.
In 4841 and 4842.
4841 also notice issued.
Yes, notice issued, we file our affidavit. But in item number 10, Lordship, 4376, the department is yet to file their affidavit, although notice has not been issued. That.
And have you filed your affidavit?
In item number 10, we have not filed.
This is 4376.
Yes,
You have not filed.
we have not filed.
But in the other two, you have
In
filed.
other two, we have filed.
Okay. We issue notice here. You
Not-
file your affidavit. It will take it. Same number. This is only in the 43760 of 2020. Issue notice making it returnable on, when do we fix it?
Lordship, after beautification,
On 7th of February?
Yeah.
Making it returnable on 7th of February 2024. So Mr. Ezekiel appears on behalf of the respondent number 2, 3, 4, 4 also,
Yes, sir.
and 5.
5.
So who appears for respondent number 1? Yes, Mr. H.K. Gupta. H. Gupta
H. Gupta.
appears for the respondent number 1. As the respondents are duly represented, extra copies of the writ petition be served upon them by tomorrow. Give the date. The respondent shall file their affidavits on or before 31st of January 2024. The petitioner would be at liberty to file their reply, if any, on or before the next date. The interim order passed earlier shall continue till the next date. And the other two also. You have filed your reply? Other two separate orders both. The respondents have filed their affidavit in opposition, and the petitioner seeks an accommodation for filing the reply. So list these matters again on 7th of February 2024. The interim order passed earlier shall continue till then. এই দুটো একটা order.
Supplementally,
Yes, you have gone through the act.
yes, my lord.
Now what are you supposed to do?
Yes, my lord. It is my lord matter of arbitration.
Not only matter of arbitration, what are you supposed to do?
But we have,
Let's read 3G5.
if the amount determined by the competent authority under subsection 1 or subsection 2 is not acceptable to either of the parties, the amount shall on the application by either of the parties be determined by the arbitrator to be appointed by the central court.
Then 3G6.
Subject to the provisions of this act, the provisions of the Arbitration and Competition Act 1996 shall apply to every arbitration under
And 3G7.
competent authority or the arbitrator while determining the amount under subsection 1 or subsection 5 as the case may be shall take into consideration the market value of the land on the date of publication of the notification under section 3A, B, the damage, if any, sustained by the person interested at the time of taking possession of the land by reason of the severing of such land from other land. The damage, if any, sustained by the person interested at the time of taking possession of the land by reason of the acquisition injuriously affecting his other movable property in any manner or his
So
if
now whatever is to be adjudicated has to be adjudicated in terms with 3G, 5, 6, and 7. And there is an arbitration proceedings by which it can be done. Now, therefore, what is required is you are to move the competent authority requesting that you are not ready for this, and as such, make a reference in terms with 3G5. That's it. Why should this court now intervene? Mr. A.M. Borguia, the learned counsel appearing on behalf of the petitioner, submit that the petitioners herein are aggrieved. Petitioner or petitioners?
petitioner,
Huh?
petitioner,
The petitioners herein are aggrieved on account of the inadequacy of the compensation paid to the petitioners in respect to the acquisition made under the National Highways Act 1956. He submits that he may be permitted to file applications before the competent authority seeking a reference in terms with section 3 capital G bracket 5 of the National Highways Act 1956. And the competent authority may thereupon take appropriate steps so that the matter is referred to the arbitrator for deciding the said reference. Ms. M. Borman, the learned counsel appearing on behalf of the respondents and more particularly the competent authority, submits that if the petitioners file their respective applications for enhancement of the amount or seeking a reference in view of the inadequacy of the compensation, the competent authority shall take appropriate steps in terms with section 3G5, 6, 5 bracket 5 and 6 of the National Highways Act 1956. So, taking into account the above, the instant writ petition therefore stands disposed at the motion stage itself, thereby granting the liberty to the petitioners herein to approach the competent authority by filing their respective applications. Respective, huh? Don't file everybody like here.
Yep.
Because it will be a type of a suit. Respective applications for on account if respective application for seeking a reference to the to arbitration in terms with section 3G5. It is further observed and directed that in the circumstance the petitioners file their application, the competent authority shall refer the said dispute to the arbitration in terms with section 3G of the National Highways Act within a period of 30 days thereafter. Mr. A.M. Borbuia, the learned counsel, submits that he would advise his client to take appropriate steps within 30 days from today. You do that because if it is a delay, it will be again problem.
Okay.
Yes, Mr. Bora, you are so imposing the other side. Yes, appear.
Petitioner is not there, my
Eh?
lord. And he is enjoying a status quo order, my lord.
That is why.
We'll go.
Why is status quo?
Yes, my lord. Here the next is my lord.
Which order?
Page number 14.
Both the parties shall maintain status quo over the suit plan in respect of its alteration or changing the topography of the type of order. Civil Judge Baksa.
Already a suit has been filed and
Type of orders. How these people pass this type of orders? What is he asking for?
basically that this for now 4 has taken
Why a
PMR.
writ in the nature should not be assigned, set aside the sanction letter by its memo number issued on demand by the respondent number 3, directing the respondent not to interfere in the plot of land owned by the petitioner who is moved. Sanction letter, what is this? Should not be set. Which is the sanction letter?
My lord, page number 15. Type this is originally 16. Type 1 is 15, madam.
Sanction letter for construction of
PM under
dwelling
house,
of information.
Allegation is he is constructing over the petitioner's land.
None appears on behalf of the petitioner on call. List the matter after the winter vacations.
Public.
Mr. Esbora appears on behalf of the BTC and submits an
13. Order implement of part.
Wait, Mr. Karthik. Karthik. Number 1. That's part. I have filed for implementing tax.
whom do you want to implead now?
Respondent number 1.
Why?
Respondent number 1, earlier respondent 1, that's part.
Huh?
That's part. And the new incumbent is doing.
So, new incumbent, have you issued notice to him?
Lot.
Where? Where? He has also to know.
Chief, I have communicate.
How?
Communicate.
When? Before?
11/9/2023.
Then why have you not enclosed? Mr. So-and-so, the learned counsel appearing on behalf of the applicant, petitioner submits that 2 weeks' time may be given to him for filing an application, additional affidavit, evidence to bring on record, so that the petitioner can bring on record the document showing that the petitioner had duly intimated the present commissioner and secretary to the Revenue and Disaster Management Department about seeking compliance to the order dated
Order dated Lordship 19/2/2019. Lordship.
19/2/2019, passed in WPC number 2547/2012. So taking into account the above, this court fixes the matter again on 5th of January. In the meantime, the affidavit be filed.
Problem.
14. But
My lord, this matter has come up today for further consideration. So, my lord, we have filed another writ petition. The brother has filed. So, his prayer basically is that he wants CBI investigation into the entire modus of the crime. Means writing an application to the court to transfer the case.
What happened to that matter?
My lord, we have filed on it today.
Let's have this after vacation.
Yes. And my lord, there we are just thinking whether to make the judicial magistrate a party or not. That's right.
Don't make it.
My
Because he has a right, na?
Yes, he's protected.
He's protected. Don't make it. Because that will have a far-reaching consequence. This the Mr. F. Khan, the learned counsel appearing on behalf of the petitioner, seeks for an accommodation of the matter. List the matter after the winter vacations.
Obliged.
When you move that matter, in that matter, I have not fixed this matter because of the fact that matter notice will be issued. There you fix this with that.
I'll take both. And this is part of this will come here.
I don't know.
Obliged.
Chalo. None appears on behalf of the petitioner on call. It appears that on an earlier occasion, also petitioner was not represented. The instant petition therefore stands dismissed for non-prosecution. Interim orders, if any, stands taken.
16.
Please tell us. I am
Yes.
saying on behalf of Egos Park. Kindly pass out a message for that.
Sorry. I don't adjourn
we have taken
2015
consent from
matters. 2015 matters
Yes, sir.
should be only, what are you asking for?
For compensation.
Of how much? 5 lakhs.
5 lakh and 1 lakh.
Why?
From maternal death.
From whom? Why are you asking for compensation so much?
Lots of my senior is the better person to your lot.
Huh?
My
Yes, who is
senior
paying for the health department? No, none. Yes. And they have not filed affidavit also. So we admit that it is a case where the health department duly gave paid that 5 lakh. 5 lakh. Death on maternal death.
And that is a Easter hospital.
Hmm?
The incident occurred in a Easter hospital.
Maybe, but she became, yeah, because you are not providing her basic amenities.
Page 15, my lord, there's a report.
Yes, that is the report which I have read it.
Lord.
Finally see at page, the last part of the, but who has given this report? Huh? Mr. Counsel, you file these type of writ petitions just for the sake of it or what? Huh? It seems your senior is not serious with these type of matters. They just file it for the sake of it. It is done by the Legal Services Authority. Huh? This is somebody's life and the person has died. You are not interested. It's a matter of 2015. It is going on for the last 8 years. And you are seeking for an adjournment. We have this video conferencing. Why can't she do the matter through the video conferencing if she's not available?
He is in a remote area. He is in city.
So, when these type of matters are there, then she should be either delegated to somebody. This is a 2015 matter. It's a case of right to life. And is this the manner in which your senior is dealing with these type of matters?
As per my knowledge, Lordship, he needs to take some instruction from the petition.
Why? Heaven. So the petitioner has died. That the petitioner's family has, wife has died. Yeah. What is there to take instructions?
He has written one letter.
That these type of matters, one has to have compassion in doing it. You should not do it just for a day. If you take up these matters, you have to be more serious in this. These are not like other matters where you do it for your money. These are matters for which you need, because she is a BPL worker, person who died because she did not have the food and she had to give birth to a child at that point of time.
Lordship, as per my knowledge, he is doing this case pro bono. My senior is doing this case.
Pro bono, that is why I am saying. If a person is doing a matter pro bono, what is that to take instructions? Tell me. When the other side has not filed the affidavit, what is that? To withdraw? We don't expect this type of assistance from the court, from the lawyers. This is a very sorry state of affairs. If this particular case would have been a case where a person died out of some medical negligence of some other person out there, this court would not have bothered. I would have immediately asked you, go there before any authority, file suit. But this is a case of a BPL worker who died because of amnesia, taking into account that she was not provided the food. She could hardly have food which was provided by the ASA workers. The medicines were not given, which has a bigger field which has touches on the people, very people. And if we are to get an assistance in this manner, what is there? Let us find somebody else who is better off. Yes, Mr. Bhattakar, would you like to help this court? Because this is a very important matter. And the assistance of this type of counsel is very sad. This is a case which is a person concerned is a poor lady. She died. At the time of giving birth, she did not have, maybe because of the food or lack of food. Although she died in the tea state, that's a different thing. But what can else be done for this type of people out there? Because now there are various schemes, like various food amenities and all these things are being given. All these things. Now it's a case of compensation. Maybe a compensation may be given, may not be given, whether it's a constitutional tort or not. These are various other aspects of the matter. But here, one can get a line by which this can be made into a particular clear path can be laid down so that the people do not suffer.
Yes.
I think this is the bigger issue which is involved. I will appoint you an amicus. Mr. Gogoi, you file your affidavit in this
Well, I will
matter.
have the inspection whether anything has been given till date.
yeah.
And present
If
status
it
of
is
the-
there, it is okay. So whether there is she's asking for compensation on the ground of constitutional tort. Whether there is any negligence or not, you just find it out there. But the other is, we have to know how it is to be done so that it can be very well incorporated out there. This will help the people. Because I see a lot of similar type of litigations out there when I'm sitting out there in Kohima. Kohima, these people are very, I don't know, the division bench are very less I have set out there, but there are a lot of matters pertaining to the natal health of the woman and how to be taken into account, and the pregnancy, what are the food and everything. There are a lot of schemes of the government of India in this regard. So something can be done, This court, taking into account the matter in its entirety, is of the opinion that for a proper adjudication of the matter, this court had therefore requested Mr. S. Bhattakar, the learned counsel, as to whether he would be inclined to help this court. Mr. S. Bhattakar has readily offered his service that he would not mind to be an amicus duly appointed by this court in this matter, taking into account the issue involved. This court therefore appoints Mr. S. Bhattakar as the amicus curiae in the matter. The registry shall serve a copy of the writ petition to Mr. S. Bhattakar and also indicate his name in the cause list. So Mr. B. Gogoi, the learned counsel appearing on behalf of the respondents, shall file the affidavit in the matter on before the next date. In doing so, the learned Mr. B. Gogoi shall also ensure that the copy is also served upon the learned amicus. So list the matter again on 5th of February.
Item 17.
Yes.
This case, your lordship, you should not have come with a very limited prayer, your lord. It was allotted a state, your lordship, in Alapakar, your lordship, industrial state by the state. Now there is an enhancement of the rate, your lordship, that is at page 19. At an extra C, your lord. This is dated 20th April 2006.
Yes. No. What is this?
This is the, your lordship, rate were enhanced. For the state as well as the open space.
Okay.
Now, your lordship, although it was enhanced, the authorities, your lordship, has not
should lordship inform the petitioner, your lordship. From petitioner, your lordship, the rate was your lordship taken as the old rate. Rent was taken, your lordship, as per the old rate. Now, your lordship, at one point of time in the year 2013, he applied for your lordship regularization of his lease deed, renewal of his lease deed, your lordship. At that point of time, your lordship will kindly come to page 27. A letter was issued to him, your lordship.
Yes.
Thereby, your lordship, he was asked to pay, your lordship, the difference of the billed amount, your lordship. Your lordship will get it, your lordship. With
Okay.
reference to the letter on the subject cited, I am to inform you that as per record of his office, a factory set measuring so and so was allotted to by allotment letter number so and so. The lease deed agreement of the set was executed as per lease deed number so and so. Accordingly, the lease rent of the state allotment of factory estate was billed as per old rate, that is rupees 15 per 100 square month, 100 square feet per month, with a total amount of rupees 495 per month from July 96 onwards. Of in the meantime, enhanced the lease rent of the factory set to rupees 2.50 per square feet per month, and open space rent rupees 50 per square feet is effective from 1/1/2005. However, due to some mistake of the billing section of the office, the state allotment has been billed as a factory set in old rate with effect from 1/1/2005 and open space in new rate with effect from 1st July 2007 instead of new rates as factory set effective from 1/1/2005. The revised bill for the reference period so and so, then your lordship, the difference of the bill amount realized will be so and so rupees 6,66,170. Now, your lordship, in the meanwhile, your lordship, he filed an appeal, your lordship. Basically, his appeal is that, your lordship, although this was in 2006, this notification was issued, it was put to challenge by some of the, your lordship, leaseholder. And in that particular case, your lordship, the honorable court, your lordship, directed the authorities, your lordship, to take the loan from your, to take the, not to take the area, your lordship, prior to July 2007, your lordship. That was his prayer in the appeal, your lordship. And in that, your lordship, there is a letter from the authorities, your lordship, at page 31, your lordship. With reference to the letter on the subject cited above, I am to inform you that the corporation has already considered your prayer for executing lease deed agreement against your allotment of at industrial area Kalapahar by our letter dated 16 June 2014. In regard to your prayer for consideration of lease rent in old rate for the period from 1/1/2005 to 2007, you are requested to submit the relevant court order allowing your unit to pay the state rate. Now, your lordship, for this period, your lordship, since he has not filed, your lordship, the petition, therefore he was not being given the benefit, your lordship. And that's why, your lordship, we came before this honorable court that, like the other persons, your lordship, we should also be given credit so far as this period is concerned. They filed their affidavit, your lordship, and in their affidavit, paragraph 10, they have said, with regard to the affirmation made in paragraph number 12 of the writ petition, the deponent begs to state that the statements made in paragraph are not fully correct, hence denied. The corporation has charged enhanced rate with effect from 1/1/2005. As some of the units approached the Honorable Guwahati High Court against the enhancement of rate, the High Court was pleased to pass an order in those cases to charge enhanced rent with effect from July 2007. Accordingly, the enhanced rate was charged from July 2007 in case of the units to obtain court order. Now, your lordship, had they, your lordship, asked me at the relevant point of time, I would have also come before this honorable court at the relevant point of time. But since they did not charge, your lordship, they charged me in the old rate, your lordship, till 2013. There is no occasion for me to come before this honorable court. And on coming to learn about their stand, your lordship, I came before this honorable court with that prayer, your lordship, that I should also be given benefit for this. This is my
Lordship, your rent was enhanced in 2006 with effect from 1/1/5.
Where is the order?
Lordship, I have
One order. I have only this. But there is a detailed order passed by the Honorable Court. I could not find out. Type of-
This is a consent order.
Based on the earlier order. That was the stand also of the department. Now what is submit your
If your lordship is passed the order similar to this order, then authority will consider, because our stand at paragraph 10.
So you would not, your stand out here is that for the period up till 2007. Till what 2000?
July 2000.
1/1/2005 to July
1/1/2005.
5, because the rent was enhanced in 2006 with effect from 1/1/2005.
So for the period from 1/1/2005 to
2007, Miller. Is
2007 when?
31/7/2007. 31/7/2007.
How do you say?
Because this lordship
1/1/2005 to so and so. You are not going to take the enhancement.
since some of the unit Miller obtained the order, and after getting the order, authority give relaxation to that part Miller. So if lordship is passed similar order, then definitely
Help us subject to your consent.
lordship may consider this order and pass. Otherwise, we have submitted the because at paragraph 10 Miller, we have stated.
Well, this is a consent.
Yes. Otherwise, lordship may consider whether this.
But as regards from 1/7/2007, you have no.
Yeah, no. I will have to, Your Lordship, because that issue has been decided by this Honorable Court, Your Lordship. And that July 2007 is because, Your Lordship, on that particular date, the order has been passed by this Honorable Court, a detailed order. That I could not find out.
That I have seen it. Those are also consent.
Yes.
Yesterday, some
Lordship.
these are all the same.
But that enhancement was with effect from 2000 Miller. That not also
That is for Bongaigaon.
boy.
Okay, that is.
But the same judge passing the same order.
Because due to
The instant writ petition has been filed by the petitioner. Challenging the notification number CI.129/2002/63 dated 24/2006, issued by the Additional Chief Secretary to the Government of Assam, Industries and Commerce Center, semicolon. The communication number AIIDC/128/2013-14/3212 dated 29/2013, issued by the Managing Director of AIIDC, as well as seeking a writ in the nature of mandamus not to impose the enhanced rate on the writ petitioner in respect to the industrial shed retrospectively with effect from 1/1/2005. The facts next. The facts as would be discerned from the writ petition is that the petitioner herein had taken a plot of land measuring 1 katha 4 lechas covered by dag number 718 and 134 included in patta number 829 at village Patasil, Kalapahar industrial area for running a manufacturing unit of steel furniture. In that regard, a deed of lease was executed between the government representative and the petitioner's father on 6/11/1989. By the notification date 24/2006, the additional chief secretary to the government of Assam Industries and Commerce Department enhanced the rate of industrial shed and industrial rate of the industrial estate, Bamuni Modams, CITI, Kalapahar.
Lordship, though initially it was an open space, subsequently that was converted to that factory site.
Understood. These are the facts. And let me narrate the facts. In terms with the said notification, the rent for the shed in industrial estate Kalapahar was raised to rupees 2.50 and that of the open space from rupees 0.50 paisa to rupees 0. What is this?
There is two part, Miller. With effect from 1/1/2000,
Land from 0.50 to 0.70. You had taken MIE or what? IA. In which one? Industrial estate?
Industrial area Kalapahar.
In the said notification dated 24/2006, there was various increase in the rates in respect of industrial estate Bamuni Moidam, MIE Kalapahar and industrial area Kalapahar. As the instant repetition pertains to the industrial area Kalapahar, it is relevant to take note of that the rate for the shed rent, which was rupees 2.50, was kept intact at rupees 2.50, but the land rent was increased from 0.50 to 0.70. The record further reveals that the industrial estate, which was earlier managed by the Industries Department of the Government of Assam, was taken over in the year 2007 by the AIIDC. The petitioner number 2, the petitioners claimed the petitioner had reconstructed the factory and submitted a representation on 5/5/2007 before the authority, praying to allow him to pay lease rent in respect of the open space rather than the shed. It is also claimed by the petitioner that the respondent authorities duly accepted the same and charged the petitioner with the lease rent only on the open space rather than that of the shed. And thereupon, the petitioner was regularly paying rent at the rate of 0.70 per square feet, which comes to around rupees 8,250 per month. It is also seen from the records that the managing director of the AIIDC, by the communication dated 29/2013, informed the petitioner that the lease rent of the factory shed was billed as per the old rate at rupees 15 per 100 square feet from July 1996 onwards. However, the lease rent was increased to rupees 2.50 per square feet for the shed and rupees 0.70 per square feet from 1/1/2005. However, it was also mentioned that due to some mistake in the billing section of the office, the said allotment was billed as per the factory shed in the old rate, that is with effect from 1/1/2005, rupees 15 per bracket, rupees 15 per 100 square feet, oblique per month, oblique month, bracket close, and as open space in the new rate with effect from 1st of July 2007, rupees 0.70 per square feet per month, instead of the new rate as factory sale with effect from 1/1/2005. Accordingly, a revised bill was sent to the petitioner and directing the petitioner to deposit the difference of the billed amount to the tune of rupees 6,66,270. It is also seen that the petitioner had filed an appeal before the authorities concerned, which, as per the petitioner, was kept pending. On the other hand, as the respondent authorities were insisting on the payment of the entire amount, the petitioner therefore has approached this court. The record reveals that pursuant to the filing of the instant petition, notice was issued on 21/9/2015, and in the interim, it was directed that if the petitioner had deposited an amount of rupees 2,10,000 by the 21/9/2015, the balance amount of rupees 6,66,270 be not insisted upon by the respondent authorities. The record also reveals that an affidavit in opposition was filed by the respondent number 3 and 4 on 15th of December 2021. Before taking into note the contents of the said affidavit, this court finds it very pertinent herein to take note of the submission of Mr. S. Gotaku, the learned counsel for the petitioner, who submits that against the increase of the rent by the notification dated 24/2006, various tenants, lessees, had approached this court challenging the increase in the rent. However, the petitioner did not approach. The learned counsel submitted that those persons who approached this court orders were passed by this court to the effect that for the period from 1/1/2005, 1/1 to 31/7/2007, the increased rent should not be insisted upon, as the petitioners therein, the lessees, have agreed to pay at the enhanced rate from 1/7/2077. 1/7, na? So it will be 31/36.
31/7, it will be 1/8.
1/8
From 1/8. In the same perspective, this court therefore now finds it relevant to take note of the affidavit in opposition filed by the respondent number 3 and 4. A perusal of the said affidavit, more particularly at paragraph number 10, reveals No, here the order says the High Court was pleased to pass order in those cases to charge enhanced rent with effect from July. So it will be 36.
July. Starts from July.
Yes.
30,
So it is 36.
1/8/17.
36 day. 1/1/2005 to 36/2007. RE2 from 1/7/2007 open. Paragraph 10. Wherein it has been duly mentioned that those persons who have approached this court and had obtained order, benefit of not imposing the enhanced rate during the period from 1/1/2005 to 36/2007 was granted. However, as the petitioner herein did not approach, the said benefit was not given to the petitioner. Taking into account the above, this court had put a specific query upon the learned counsel appearing on behalf of the petition, appearing on behalf of the respondent AIIDC. As regards taking into account the above, this court is of the opinion that if the petitioner herein is similarly situated with those lessees who have been granted the benefit of benefit of the existing rate during the period from 1/1/2005 to 36/2007, then the petitioner herein also should be given the similar treatment. Accordingly, this court therefore disposes of the instant with petition, thereby directing the respondent authorities and more particularly the Managing Director of AIIDC not to impose the enhanced rate in terms with the notification dated 24/2006 for the period from 1/1/2005 to 36/2007. However, as regards the period from 1/7/2007, the petitioners herein would be liable to pay as per the enhanced rate as stipulated in the notification dated 24/2006, or such other rate which have been fixed from time to time thereafter. With the above, the instant petition stands disposed.
Deputy Officer. 18.
Yes.
My lord. My lord, here the petitioner company, my lord.
Huh?
Petitioner company, my lord, is a deposit taking non-banking financial. Now, this company is thought to be brought under the purview of, my lord, the act called Assam Protection of Interest of Depositors in Financial Establishment Act 2000. Under 5A of this act, my lord, the companies are required to take a NOC from the DC.
NOC from the DC.
DC to operate their activity.
Mm.
Now, here the claim of the petitioner company, my lord, is that the petitioner company does not come under the purview of the act as because, my lord, if I may take a lottery to page 25, my lord, there is a definition of financial act. 25, page 25 of the section 2C of the act has been incorporated. Here, the financial establishment means an individual or an association of individuals or a firm or a company registered under the Companies Act and carrying on the business of receiving deposits under any scheme or any arrangement or in any other manner, and includes the non-banking financial companies as defined under so and so. So, my lord, here that they have to be receiving the deposit. But the petitioner company, my lord, is a non-deposit taking company. As such,
And carrying on the business of receiving deposits under any scheme or arrangement or in other manner, and includes the non-banking financial company as defined here, but does not include a corporation or a cooperative society owned or controlled by the state government or the central government, or a banking company as defined under so and so. Then
that is the definition of financial establishment. So, to be under the purview of the act, my lord, it has to be a financial establishment. If petitioner company, my lord, is a non-deposit taking, so therefore it is not a financial establishment. And as such, my lord, the provisions of 5A are not applicable. My lord.
what is 5A?
5A, my lord.
Where's the act?
Page 26, paragraph 28. 5A of the Assam Protection of Interest of
Page 26.
page 28, paragraph 28.
5A.
5A, as amended, has provided for mandatory disclosure and punishment of non-compliance. It provides for a procedure of obtaining a non-objection certificate by a financial establishment as defined under section 2C of the Act from the Deputy Commissioner of the respective district, if such financial establishment wishes to start operation in the state of Assam.
Then
The state provision of obtaining NOC from the Deputy Commissioner of the concerned district is also applicable to any existing financial establishment operating in the state of Assam as on date of the enactment of the Act. The authorities, like the Deputy Commissioner of the district, etc., have been given the authority and the jurisdiction to enforce the compliance of the provisions of the Act for the purpose of the instant application. To enforce the provision of 5A, the company has to be a financial establishment. The petitioner company, my lord, is a non-deposit taking. My lord, page 25 may kindly be seen. I'm sorry, 48. 48, that is the registration certificate of the company, my lord. 48, clause 5. The certificate starts from page 47, taking your logic to page 48 clause 5. Your company is not allowed to accept or hold public deposits. The next one, my lord, your company must not accept any public deposits for the time being. After the company has been in operation for a period of 2 years, if it intends to raise public deposits, it may approach the bank with the audited balance sheet for the 2 years and a credit rating assurance. Here from this it is clear, my lord, that the bank is the petitioner company is a non-deposit taking company. And further, my lord, the Reserve Bank
No. This is non-deposit for only 2 years. Thereafter,
it was filed when the scheme was thought to be
then
filed.
now what is it? Now you are depositing.
Now, my lord, I have taken
Oh, this matter is in the part 1 list. So you must be knowing it. Matter was there. Yes.
Lordship, I am appearing for respondent number 6, Reserve Bank, Lordship. As per my instruction, they had applied for deposit, accepting deposits, but it was turned down in the year 2015 last time because they could not furnish their updated balance sheet.
Then,
Thereafter, what happened?
then on one hand you are asking this and that. Have you put it on affidavit?
Yes, your Lordship.
Then
Para
on
35.
that ground it will be finished. Where is that? 4 and 5 has filed.
Was filed.
Superintendent and then the police. That the paragraph 2 and 2 deponent
Lordship, it
states
was
that
filed by-
the deputy general manager of the man, it is stated that the branches of the Northeast region financially and Dibrugarh have been sealed by disgrace. That the company is registered with the RBI as non-deposit so and so and is permitted by RBI to carry on so and so. What is NBFI activity? On receipt
Non-banking
of this
financial-
info, the matter was intimated to the respondent that with regard to so and
now of the same affidavit, my lord, page paragraph 43, page 30. Same affidavit, paragraph 43.
40, 43. You submitted that on receiving representation from the petitioner regarding the closure and sealing of the bank, this will inform the chief secretary that the petitioner is registered with the bank as a non-deposit NBS and according permitted by bank carry out when. Then
Now, if I may take your lordship to page 97 of the
no, as of now, what are you? Your banks have been closed. You cannot receive. I can give you a direction, okay. You would not require, but you cannot accept any receipt
No.
for your
No,
future.
not accepting, only
No, you are not going to accept. The moment you
accept.
accept, the certificate or this goes out. That is the only thing.
Yes, page 97 may kindly be.
But it is the authority who can say as to whether it is a financial institution or not. Who can say?
Yes, my lord, that is what I'm.
The issue is that
97. Page 97. We have received representation from Northeast Services on the issue of closure of their branches in Dibrugarh and Tinspo. We have seen informed that one have been sealed but admitted. In this regard, we advise that the above company is registered with the Reserve Bank of India as a non-deposit taking non-banking financial corporation. Accordingly, the company is
what
permitted
is MBFI?
non-banking financial institution.
Intermediate. No, you see, respondents, both of you, the only question out here, although it's a very thick, fat petition, is as to whether they are a financial institution. And whether it is a financial institution, the definition has been already given, isn't it? What is this 45I?
But they have to be incorporated under the RBI.
So,
Page
here
59.
the definition of financial establishment. Problem is, where is the act?
Alright.
Huh?
I do not have the act.
Oh, then
That is incorporated in the petition.
where is the quoted portion of section 5A?
5A.
Quoted portion.
5A. Five A is not quoted, my lord. The
Then
provision is
your entire case hinges on 5A. We don't know what is 5A.
five. As per 5A, the provision of 5A says that if a
I know that you say. Am I going to take you? Yeah, but a statute has to be decided on the basis of the language used in statute, not on the interpretation which the lawyer gives in drafting the petition. Then what do I do? Yes, both of you respondents, the issue is very small. Whether he comes within the ambit of this financial establishment and thereby he is not required under 5A. 5A, I don't know what it is. He says that for that you have to be a financial establishment. If you are not a financial establishment, the question of age doesn't arise. Come up with something as to whether he will come within this. This is the only issue out here. Anything else? Well, why do we need to look into the long things out here? Not to enforce here, written the mandamus here, and not other things, including the deputy to rescind, recancel here. Because this is, and what is the deputy commissioner doing? Who is appearing for the deputy commissioner? Yes, you. What is your stand? Why have you done that?
I need some accommodation, my lord, for
Why?
today because the office is yet to locate the file. I
Which
have
file?
this concerned file.
You are using my
No,
second file?
No, he is using the second.
You are using the second
He is
file?
handicapped today.
Very well.
that is why I made it clear in the morning. I'm handicapped today.
Fantastic.
I'll get a copy from my friend and accordingly I will have the info.
Look, the issue involved herein is to whether the petitioner company is a financial establishment within the meaning of section 2C of the
Assam protection of interest of depositors.
Assam Protection
of
of
interest.
Interest of Depositors bracket in Financial Establishments bracket close Act 2000. It is a submission of the learned counsel appearing on behalf of the petitioner that in view of the language employed in section 5 capital A of the said Act of 2000, the requirement of obtaining a no objection certificate would only arise if the petitioner company is a financial establishment within the meaning of section 2C of the Act. Taking into account the specific issue, this court have the learned counsel appearing on behalf of the respondents, more particularly the deputy commissioner, the district commissioner, who had imposed certain restrictions on the basis of the said Act of 2000, has sought for some instruction, sought for some accommodation. List the matter again on 4th of January for final disposal. No more. You get whatever you like to it, but we require that act and just find out as to whether it will come within the ambit of it. That's all. Without the act, it is very difficult.
19. Thank you, Lord.
Hmm.
It may be taken out of some time.
Okay, list the matter after the winter vacation at the request of the
Lord, my
petitioner.
senior is another photo.
I can't help it. Yes.
Next is your lordship, your lordship, order dated 9/7/2024. Ask the petitioner to file an additional affidavit. The third,
Yes. Annual patta.
my lord, in this matter, no such record is found regarding Invel Patta, my lord. This is one of
Huh?
no such record, my lord. And
Till when did you pay?
Lord, they have contacted the petitioner, but they didn't again. They did not give us any information. They
Then
contacted
what basis we are going to know? No. Now what has happened? Now it has been made Miyadi.
that becomes government first claim, my lord. That's for our occupation.
No, you have made it very well, but the question is, can you make it without any cancellation proceeding?
That record is
So then,
one certified copy regarding that order. That
so
much.
that is not there. You can't on your own do it. If he has not paid, then you have to issue the cancellation notice.
Notice, my lord. But
Isn't that, madam? Isn't that the law? That if a person does not do it, so you have to issue cancellation notice. Then,
no notice has been issued.
but you are not helping this cause of this court to help you. How can I help you?
Client is not
Pursuant to the order dated 9/11/2023, the Miss M. Borman, the learned junior government advocate, has placed before this court certain instructions along with, we keep this,
right.
it's a certified copy only,
Yes, yes. my lord. It's a
along with the
sign
certified
law
copy
down there.
of the tag number 283, a certified copy of the chita pertaining to tag number 283 of village what is this village?
The part three,
Raz, no, that Remidari? What is the village? Of here you go. Of the tag number so and so. Chita of tag 283 of of the land in question, which is the land in question. The same are kept on record and marked. The same are collectively kept on record and marked with the letter X. The learned counsel for the petitioner, however, submits that she has no instructions as regards till when the petitioners have paid the land revenue pertaining to the land in question. Full stop. She seeks for an accommodation for another 2 weeks in this regard. List the matter again on 10th of January 2024.
Obliged.
Yes. Tell me.
With the Lordship.
Hmm.
Lordship, I am one of the co-partners covered by doc number 405, 277 and 278 for the revenue village Pamohi under other circle Lordship. Lordship, in this case, respondent number 4 is the land giver who has occupied our land lordship, and respondent number 5 to 9 under 9 under 10 of doc number 405.
Yes, madam. You filed the affidavit.
You have not filed my.
What? You have not filed the affidavit. Why?
Office note, your lordship, kind of key office note of 1612. 16.
Yes. No, not necessary. List the matter again on 1912 on which state Mr. P. Naik apprised his court as to what is the stand of the GMDA. The said stand of the GMDA be brought on record by filing an affidavit. What is your stand?
Matter in this case, matter we have issued notice to the respondent matter in
What is your stand?
matter as the title is pending in the court below matter. That's why matter.
Yes, Mr. P. Naik, what is your stand?
Lordship, we have already issued notice and we have clarified that no NOC has been issued, Lordship. So if
Why haven't you put it by way of an affidavit?
we receive it.
We do one thing. We'll ask that particular CEO to be present tomorrow. And on that day, he'll let us hear it from him.
Instruction is.
No. We have asked you to file an affidavit. You have not filed an affidavit. So better ask the CEO to be present out here. Then we'll ask him on his face and then record it. Nowadays, we have it, this advantage. So taking into account that there was a direction passed by this court, the affidavit has not been filed, nor the stand placed, nor the stand of the GMDA placed before this court. This court has no other option but to issue direct the chief, what is that?
Executive officer.
Chief Executive Officer of the Guwahati Metropolitan Development Authority to be personally heard in the matter. Accordingly, list the matter again on Thursday at 10:15 a.m. on which date the Chief Executive Officer, GMDA, shall be present through the video link provided to him at 10:15. Full stop. It is made clear that the Chief Executive Officer shall also apprise this court as to what steps, effective steps have been taken in this regard by the GMDA.
Otherwise, also we will receive this instruction on 15/12.
So I can't help it. I've asked you to file it by 15/12.
But by Thursday, Lordship, I will file it.
In the meantime, the chief executive officer of the GMDA would also be at liberty to file the affidavit, but he has to be present. This is not the way. He's a land grabber. What is this type of things that are going on?
I on my behalf, Lordship, I apologize. Lordship, it is my responsibility.
Then
Lordship,
2 o'clock.
Lordship, by tomorrow I will file this.
And tomorrow at 2.
Lordship, his personal affairs.
Tomorrow at 2.
In any case, Lordship, I will file. And we have taken the stand that no NOC was issued. That is our stand.
What have you done?
No action was taken only because.
No,
of the
if
pending
no
litigation.
NOC is done, what are you doing?
Lordship, first notice was issued on.
No, no, Mr.
23.
No, Mr. Naik, the thing is, what are you doing? Are we to understand? That is why we need the CEO. Are we to understand that the CEO or the GMDA will keep it or would not do anything, just keep out there that okay, there is a fight between all these things, whatever may happen, but without if there is a private dispute out there, we don't require anything. Let them fight out whatever may be, but enforcement of the act is not necessary. Is that the stand? That is why you have not filed the affidavit when there was a direction.
No, that is
Because they have to say that what is the stand out here as to what they are doing. Merely issuance of notice is not sufficient. What are you doing? Then are we to understand that the GMDA has no teeth? We'll put it on the affidavit. Put it on the affidavit that the GMDA has no teeth against land grabbers. Put it on the affidavit.
Lordship,
Then we will say,
by tomorrow, Lordship, I am going to file this certificate.
file a proper affidavit, then only, not on any other affidavit like this.
Lord.
What effective steps are being taken out there by the GMDA? If you, on the last occasion, if I remembered in this matter, you said there's a dispute between both of them which is going on, so the GMDA is not there. I asked you whether the GMDA is a party. No, the GMDA. Then what stops you from taking action under 86, 87? Then why do you at all take steps at all under the 86, 87?
Lord,
Don't
87
this-
notice was already there, Lord.
So what is this
15,
notice?
Lord.
What is that notice for? Not to stop construction?
Yes, Lord.
And what do you write on the last paragraph out there? If you don't remove it, we are going to exercise our powers. What have we done? Sleeping toilet. You're just sleeping over it.
Yes. Second
Yeah.
notice, order was not.
Or is this threat which is being given is toothless?
No,
Yeah.
Lordship, I am going to file this certificate by tomorrow, Lordship. Decide.
Okay. Ricardo, list the matter again on Wednesday, on Thursday. On which date? Full stop. Taking into account the assurance given by Mr. P. Naik, the learned counsel, appearing on behalf of the GMDA, that the affidavit would be filed without fail by as regards the stand of the GMDA by tomorrow. Full stop. 21. Any question? At 2 p.m. 21 at 2 p.m.
But his personal appearance is not picked up.
2 p.m. Person appearance to that.
23. Right.
But Mr. Naik, kindly show your teeth. We do not want that the GMDA should be like this. Do something. Otherwise, people would not have any respect from these authorities.
Lord.
Yes, Mr. Ali.
May it please the Lord.
Hmm.
Lord, here, my lord, the land, Lord, measuring 1 bigger, 1 kata has been acquired, my lord.
Hmm.
Out of my lord, 2 bigger, 4 kata, 14 less, sir.
Hmm.
And my lord, after my lord, acquired, my lord,
Release the excess land measuring 3 kathas covered by so and so illegally occupied during so and so. Okay. What is the stand of the respondents?
the last occasion, my lord, affidavit was supposed to file
Affidavit filed.
by the respondent, my lord, they have not filed, my.
Oh, yes,
Although
filed.
they-
Na? As
they-
per the record, it is seen the purchaser did not purchase the aforesaid land to register demand. Husband has actually possessed the land of so and so of dark number during the time of acquiring of the land and
Of page
now what do you want?
Of page 29, my lord, there is a order, my lord, letter from the additional deputy commissioner, my lord, to demarcate the entire land, my lord.
Hmm.
It was not carried out. Page 29. On the basis of our application, my lord.
That was done, paragraph 10 of the counter affidavit.
Demarcated the land physically and found the equivalent amount of and it on the lot control and other of the extreme the alleged difference of the land measuring might have occurred at the completion of the So you are the owner of the land.
Lost it.
What is the as per the record? It is seen that the purchaser did not purchase the aforesaid land through registered sale. Well,
Oh, my lord,
how did you own the land?
my lord, they have parcels, their name has been muted in long back, my lord. And,
How?
my lord, regarding registered deed, my lord, I have not.
That is why we don't see a reply.
Now, my lord, in the,
Otherwise, Mr. Ali is very quick in filing reply.
my lord, in
But
the,
we don't see a reply, maybe the reason why.
and in
File
the-
your reply, better off. Else we are going to accept this, what it is, and then you don't have a case. Mr. R. Ali appearing on behalf of the petitioner seeks for an accommodation for filing a reply to the affidavit in opposition filed by the respondents. This is the matter again on 24th of January 2024. In the meantime, the affidavit be filed.
But the matter may be taken after the
Yes, Mr. Goswami on the
Yes, sir,
theory.
payment has been made. Madam.
Huh?
Payment has been.
Payment got the payment.
Yes, this is the instruction. Even my lord, Deputy Commissioner also filed affidavit
Okay.
saying that he has received the amount. Very contact. No, I did not take.
How much?
2 crores.
Well, how much did the petitioner get? This is fixation of ceiling.
Total amount is 2 crores 71 lakhs 37,631.
And the deputy commissioner has filed affidavit.
Yes. Paragraph 7, my lord.
7 and 9.
7 and 9.
When? Paragraph?
7
7
and
and
9.
9.
When did they file the affidavit?
Affidavit filed on
Zero taken.
6th of June 22.
Yes. This was filed in 2022. What instruction you have?
Respondent number 4 have filed affidavit.
Huh?
Respondent number 4 have filed affidavit. Now we have to take instruction.
What do you want? You want to? I can't hear what
He wants to take instruction from his client.
Oh, affidavit filed in 2022. You want to take instruction now? Well, they're not interested. You're sleeping over it. We issue rule. Let it come up in 2029.
And this will also form part of the record.
Huh?
This is also this communication maybe.
Now, this very aspect is also there in the affidavit.
Yes, that is there.
Then we're not interested. But has he got the money or not? I'm not concerned.
Exactly.
That aspect is not clear.
Not clear in the affidavit.
Neither these documents are clear.
But the
But you can be able to.
acquiring authority received the money.
Huh?
Requiring authority paid the money. Acquiring authority got the money.
No, understood. Acquiring authority got the money,
Right.
and the payment was made by the requiring authority.
Requiring authority.
Yes.
But the disbursement is to be made by you.
Yes,
Have you done that?
Acquiring authority will disperse.
that is not clear. It only speaks about the
2022.
estimate.
Certainly, one does.
No, you never know. You may know many things, but not here. Ms. Ashwama, the learned counsel appearing on behalf of the Deputy District Commissioner. Which one? District? Gwalpara.
Number 4, Madam.
Gwalpara.
Walpar.
Shall take appropriate instructions as regards as to whether the amount which have been received have been duly paid, disbursed to the petitioner. And further as to how much amount has also been disbursed to the petition. List the matter again on 8th of January. Get your instruction.
Alright.
Yes, Mr. Bora.
If either, if either all petitioner under the portator of the particular land minor and land that they had came before the honorable court for non-payment or adequate revised compensation amount of acquisition their private land. But what happened, my lord? Similar same area, my lord, others was given the enhanced by the arbitrator on the basis of arbitration. But my case is now, my lord, after filing the affidavit, they say that they acquired the land on the basis of Land Acquisition Act 1894. But we have no notice, no any opportunities were given, no circulated in tribunal. But affidavit said that they only Assam tribunal. They are the poor person, they did not know about the Assam tribunal. But regarding in as per law is concerned, my lord.
People.
The Land Acquisition Act 1894.
Okay. So how many petitioners are here?
My lord, only my lord 19 petitioners.
Only 9. So 19 petitioners all are asking for one amount.
No, my lord. Now we are amount is the concern, but regarding the affidavit filed by the
I'm not on that.
my lord,
Are they have the same cause of action?
regarding court system.
Yes.
At that moment, my lord, in 2021. Now I am doing
2021 means the law was there from 1948. You have to pay.
Some time maybe. Pay the
Mr. N. Bora, the learned counsel appearing on behalf of the petitioner, submits that as there are 19 petitioners, but only the court fee of one petitioner has been paid, he shall pay the deficit court fee. This the matter again on 22nd of January 2024. In the meantime, the petitioner shall pay the deficit court.
26.
Lordship, to kindly have a look at the last order, madam.
Yes.
Basically, Lordship wanted to know whether we filed any objection on 6 to 19 before passing of the making the provisional assessment final. This court, upon hearing the learned counsels appearing on behalf of the parties, and more particularly taking into account the physical verification and testing report dated, which have been signed by the officials of the respondent APTCL, as well as one director of the petitioner, would like to be apprised as to whether petitioner at any point of time prior to preparation of the final assessment had raised any issue that the petitioner was asked to sign the report without permitting petitioner to have a look at the said report. It appears from the final assessment order that there is a reference being made to communication dated so and so filed by the petitioner. For the purpose of perusing the said aspect of the matter, records pertaining to assessment so carried out by the petitioner would be required. Accordingly, list so and so on that Mr. Parker, learned standing counsel above shall ensure say record that put. And in fact, my lord, we filed a complaint on 6-2 where we raised all these points. None of the points have been discussed.
The petitioner did file a objection to the provisional assessment. There, what he has stated regarding this aspect of whether he was not allowed to check the testing report, he has stated that the meter was seized in the year 2016 and the testing was done only in the year 2019. And though the said meter was tested in presence of the directors of the appellant, but there appears to be some error. Till then, it was unilateral test, as because whatever the department has done, the appellant had no other option but to sign that. But he has not stated that he did not know what its contents were. He has stated that he had no option but to sign. That is his statement on 6/2000.
No, as regards the provisional assessment bill,
Okay.
did they file an objection?
Yes, I am reading from the objection.
Now, in that objection, what order have you passed pursuant to?
Pursuant
Then
to
you
that-
have to make the my case final.
Yes, that order is there on record.
19-1. 8-8. In fact, if a lordship will kindly have the ground number A at page number 3, my lord. That prior, as a lordship got it, that prior to seizing of the meter, the concerned officer was taking reading of the meter, and it was never reported that he has found anything in the meter. And it is clearly mentioned in the inspection report dated 7/6/16 that clearly stated as meter cabinet seal found okay, sealed by IRCA for the meter reading. And if the meter cabinet seal is found okay, then how anyone could, malpractice the meter? That the number of the meter cabinet seal which was done by APDCL was not mentioned in the report, and it was also not mentioned who has sealed the meter cabinet. And if the meter cabinet seal is found okay, and after that, at the time of testing and after opening the seal, if anything contrary is found, then it could be safely presumed that defective meter was being installed. That if the average bill prior to seizing of the meter and after the seizing of the meter are almost same, and even it is much lower than the earlier meter, then that too after enhancement of the unit charges, then why the appellant will commit malpractice by tempering the meter if it is not giving an illegal gain to the appellant? Because, my lord, the meter reading was less after the new meter was installed. Now, this is important that the meter was seized in the year 2016 and testing was done only in January 2019. And though the said meter was tested in presence of director of the appellant, but till then it was unilateral test, as because whatever the department has done, the appellant had no other option but to sign the report.
Have you brought on this aspect by way of an affidavit? Bring it on.
Very well.
Then the record is complete. We'll have it for final disposal on when?
My lord, can it be up post 10th of February?
When?
Post 10th of February.
We can have it on 13th of February.
Yes,
Very well.
we'll bring it on record.
Pursuant to the order dated 23/11/2023, the Mr. K.P. Pathak, the learned counsel, standing counsel for the APPCL, have produced the reports. Mr. K. N. Chaudhary, the learned senior counsel, has also drawn the attention of this court to the appeal memo.
Oh, it was an objection.
No,
Objection.
this is an appeal under 126(3). This is done under that proviso. This is against the provisional assessment.
This is against the provisional assessment.
Yes.
No, in the appeal memo is there.
In the before the appellant.
Actually, my lord, it should be an objection. Because
Is there actually
Supreme Court has also
I
said,
produced the
so it
appeal
has been
memo.
described as an appeal memo.
I had produced the objection filed in terms with section 126(3) of the Electricity Act 2003 against the provisional assessment. This court finds it proper, finds it apt to observe that these documents be brought on record by way of an affidavit. Mr. K. N. Chaudhary, the learned senior counsel, submits that the said document would be brought on record by way of an affidavit. List the matter again on 13th of February 2024. On which date the matter shall be heard and disposed of. Mr. K. P. Pathak shall also produce the records on the date.
27 and 28. Interim to continue.
The interim order passed earlier shall continue.
Timing.
You have filed your affidavit?
My lord, inadvertently, what has happened is that the affidavit.
Councillor President, another foot number 12.
My
You
lord,
filed the affidavit?
the affidavit had come, my lord, but what has happened is it was misplaced and could not be filed. However, I have a copy of it where the clarification is made. Copy of
Copy with
the
something
notarized
on the
affidavit.
backside.
Notarized affidavit that was sent.
When are you filing it?
My lord, I'll have to get a fresh affidavit kind of made and then.
Ask the person to come over. I do one thing. As you have not filed, we'll ask them to have a personal appearance. To get his affidavit
They
signed.
sent it on the 11th. My lord, may kindly have a look at the cover letter. It was sent on that day, I mean the next day, by hand. And it was misplaced, that's why it could not be filed. The clarification that is sought for is made in para 3 of that affidavit, 40 affidavit. When it is stated that the claim made by the petitioner is not true, as although his bills were signed, that is with respect to case number 8854 of 2021. It says as although his bills were signed, but in practical, the materials were not received against the scheme. And in the other affidavit, my lord, the standard is taken is the claim made by the petitioner is not true, as although his bills were signed in full, but in practical, only the materials amounting to rupees 1,40,071 rupees was received against the scheme. He's made claims of, my lord, in both the date. In one, he's made a claim of.
Devnath, what is the date of this communication?
This communication was made, my lord, on the 16th of November.
Okay. Thereafter, on 24th of November, I passed the order and making it very clear that if you don't file it, no further opportunity shall be given.
My lord, can you take my oral submission as regards the clarification?
What clarification?
There was a clarification sought for by the previous order. Sir.
No. I have only asked you to file your affidavit.
Yes, my lord.
I have sought for 910.
Yes, ma'am. And it says
Because he
clarifying the petition
says,
as to
no,
whether
he says, I remember his
Yes,
case. He says that, look here,
I'm the supplier.
I am a supplier. I am not a person who is doing a
That's right.
contract. And as
Exactly.
such, the question does not arise for all these things. It is under such circumstances this court have sought for your instructions. It's a specific submission of the learned counsel for the petitioner. The petitioner had only supplied the goods in question. The question of implementation of the work is to be done by the department as that is the mandate as per the scheme.
Exactly, ma'am.
And as such, whether the work was implemented by the department or not is not the subject matter. The learned counsel for the petitioner submitted that in the instant case, the documents would clearly show that the petitioner had duly supplied the goods and as such are entitled to it. It is under such
My
circumstances.
lord, it is undisputed that
Then-
the petitioner is the supplier, my lord. But as far as the amount that is claiming for, my lord, there is a dispute, my lord, in that regard.
What?
Para 3 of these affidavits which are previous, my lord.
This affidavit has no meaning. You have not filed. So we'll take it that you have not filed it.
That
You
is true,
don't
my
want
lord.
to
But
file.
may I actually beg of the court to actually take accept my oral submission.
You have taken this court for granted.
No, my lord.
Yes.
Definitely not.
No,
Definitely not. And never, my
absolutely.
lord.
No, thereupon, this document was very much available with you. If this document was available, and thereafter also I passed the order on 24/6. This document, the affidavit was signed on
These
16/11/2003.
affidavits had been misplaced. That's the problem.
From where?
Had been misplaced from our office,
Whose office?
our chamber.
Then also I gave you a month.
That is true.
Then it got misplaced prior to this. It seems that you have taken this court for granted.
Never, my lord. Never.
It's a very dangerous
Never,
thing
my
to
lord,
take
never,
this court for granted.
No, my lord. Never.
So we do one thing, as he is not in a position to come,
No, my lord.
he's not signing it.
He has
Let
signed
him
it.
come. You take out the printout. We'll ask him to be present tomorrow. at 10:30.
Malad, they are actually having a training program. He's in Guwahati, Malad. They are
Where he see, this is the matter on Thursday. After Mr. N.K. Devnath shall file the affidavit by tomorrow.
Malad, by day after tomorrow, Malad.
Tomorrow. He's in Guwahati, you say.
He is
Now,
in Guwahati.
how can you say?
Malad, I'll have to get it. He's in a training program.
So what?
I'll speak to him.
He can come at, he can even come at
Just one
6.
more extra day would have
You
been
can even
some-
ask him to come at 8 o'clock at your place, get it notarized, and then file it. So you can file it tomorrow at 10:30. Don't.
Alright.
But this is it was, the amount has already been debited from the account of the government. The second page. First page is and it was adjusted from some other account, but even then not we got.
The order. He will get it today. No,
Yes,
the order dated 28/7/2023. Passed in WPC number 1277/2023, having been complied with. As is evident from the document placed by Mr. H. Sharma, the learned counsel. The instant this court finds no good reason for issuance of notice in the instant contempt proceedings. The said documents are kept on record and marked with the letter X. Accordingly, the contempt proceedings, contempt petition stands closed. You give him a copy of it.
We can keep you.
Mr. Counsel, in the other two matters, take the pain of giving a copy to the Commissioner and Secretary by hand, not by this manner and sending it by registered post. It doesn't act like that.
29.
In this case, my lord, affidavit opposition has to file, my lord.
You sought for accommodation last time. Why?
Because, my lord, there was a point raised, my lord, regarding, my lord, maintainability.
Now
But
tell me
subsequently,
why.
but there was already
Why?
order, there is an order, my lord, to file affidavit in opposition.
Forget about the affidavit.
Yes.
We won't disturb them. First, you
Maintainability, my lord,
you-
I objected that, my lord, without hearing us, my lord, during the lockdown, that order was passed by the revenue board. That's why I objected that any order passed without me, my lord, without the petition or my lord, appellant, my lord, that cannot be maintainable.
why?
That was the point, my lord. But subsequently, as your lordship has pleased that no matter to be heard on merit. That's why matter.
No.
But otherwise, there is an order, my lord, from this honorable court for 123 to file affidavit.
Why do we need an affidavit out?
By
I
the
am asking you this. Why have you challenged this order?
Yes, my lord. I have challenged, my lord, because, my lord, I am already in possession in that land, my lord,
Hmm.
and purchased this, my lord, the land, my lord,
Hmm.
in the year 1982.
Hmm.
And, my lord, without hearing us, my lord, without serving any notices to us, my lord, they have
Thank
passed
you, Lord.
order, my lord,
I-
the respondent authority. Even in the record also, that is not met there, my lord.
Lordship, can I to see page number 68? Here then,
68.
68. This was a bill filed by them in the year 2020.
Hmm.
They have to remain silent.
Hmm?
They have to remain silent. Then this order was passed on merit.
When it was hearing, fixed on hearing, it was.
On the last occasion, that is on so and so, a chance was given to both the parties to give their final submission. But the learned counsel for the appellant remained absent.
Well, during the lockdown time, my lord.
What was this lockdown on 17/11/2020? There was a lockdown.
Lockdown, my lord.
Show me that. Show me that there was a lockdown. Don't
From
make
March
this that. Mr.
2022.
Das, you know,
No, my-
earlier one matter,
Okay.
you are on a very thin ice. That matter. Yes.
For here, for
Now
this happened actually, my lord, learned counsel was there, my lord.
Huh.
Other side was not present. But
But
supposed
Mr.
to inform by the
Das,
officer.
17/11/2020, there was no lockdown. The lockdown finished sometime in the month of August.
Regular court was not there, my lord. Then, my lord.
Regular
Some
court was
both parties
functioning.
present, court takes up the matter. In revenue board also, my lord, our office bearer told me that when I appeared there, my learned counsel who was engaged there, he is supposed to appear there, my lord. And when office informed that, my lord, he will be told.
Did you submit?
Okay.
You then produce the certified copies of those orders. We'll see
Yes.
whether there was a date fixed on that
Yes,
particular
my
date.
lord. On the next date, I'll submit.
Yeah. That is the reason
Yes,
why.
yes, my lord. When it was fixed for hearing, my lord, and behind my back, my lord, that
What
order,
behind your back?
because my lord, learned counsel was supposed to inform by the office bearer in the review
Why?
board. Then office bearer, my lord, in the review board.
Mr. Das,
Okay.
are you saying that this court doesn't know how a Board of Revenue functions?
Yes, real.
Don't make these type of submissions before this court. Then you don't have a case. You dismiss it with cause.
On the next date, my lord, I'll place my lord. When it
Course.
was fixed. And,
You have not been able to pursue anything.
and my lord, without hearing us, my lord,
What is there to hear?
Lordship,
What is there to hear? You have been given ample opportunities. You have not been present.
the first order, what has been passed by the officer, my lord. First order, what has been challenged by me in the revenue board, that order, prior to that order, there is no record also, my lord. Field verification was also there, that record is not also in the place in the revenue board record, my lord.
So what?
So
You
on
were,
what basis
you
that
were
order-
supposed to point it out before the revenue board. Why were
that
you
was
not
pointed out,
present?
my lord. That was pointed out, but that has not been considered, my lord. In the revenue board, I have.
So you were present.
Our RTA report.
Now, are you saying that you were present on site on
No, my lord,
22/12?
prior to that, my lord, I have
No, not prior to that. Or
RTA.
whether you were present on 22/12.
My lord, page, lordship, page 58, my lord. Page 58, my lord, I just want to, just, my lord. These are the queries, my lord, filed by the petitioner before the, my lord, for RTA information, deputy commissioner, my lord. Certified copies of the land, number so and so, documents so and so, any notices served to Mycena Laskar petitioner and family before.
This is an RTI.
RTA, my lord.
How does this have
Because-
any relation with that?
Because, my lord, prior to this order, what has been challenged by the, before the revenue board, my lord, well, that order has, prior to that case order, my lord, notice not served upon the appellant, my lord.
Are
That's
you
why.
saying that you filed the appeal without an order?
No, these papers we did not receive, my lord.
Forget about that. Did you file an appeal against that order?
We
Against
filed
some
a- yes,
impugn
we-
order, you must have filed an appeal.
Yes, we filed.
Because as per the Assam Board of Revenue
Yes.
Regulation, you are to required to file the
Yes,
certified
my lord.
copy
That
of
is
that.
also not in the record. That notices, copy of the notices, what has been served upon us, my lord, that is not also in the record.
Not
We not-
necessary. Have you challenged that impugn order or not?
Yes, silence, that is.
Which is
before
the
revenue
impugn
board.
order?
Revenue board, it was silence, my lord.
Then you were not present. Why should we consider?
Possibly kind of page 46, my lord. Order passed by the ADC. After recording their statements, after perusal of all their documentary evidences, my lord, page 46.
Page?
Page 46, my lord. Order dated 29/9/2010, my lord. Passed by the ADC, cancelling Rayati Khatyan.
Huh?
Cancelling Rayati Khatyan upon application of the.
Then?
And my lord, in this entire proceeding, they have appeared before the trial magistrate ADC. They have submitted their documentary evidences. They have admitted that they have purchased the land. And at that time of purchase, the purchaser was not an agricultural.
Grounds, my lord, I
He
have
was-
said in it,
He was a
page
railway,
6, my lord.
railway employee. Therefore, he has constructed RCC building over this land. This has been recorded before the ADC, my lord. Then this
No,
order was passed.
There is no record in the revenue board.
From he has been saying,
Deputy
my lord, I
commissioner
don't know.
also. I have seen, check it out. No. Field verification also not there by the Mondal matter. is missing, my lord. That's why grounds were, my lord,
There is no interim order also.
no interim order, no interim order.
There was an interim order of status quo,
Page 6, my
which
lord.
I extended till the next date.
Yes.
Thereafter, there is no.
No. Page 6, my lord. Authority grounds, my lord, reporting.
So we do one thing. Take your time and prepare the matter properly. We issue rule. When you get designated as senior advocate, by then the matter would be heard in 2030, 32. Huh?
No,
What do you say?
no, my lord, my lord. Here, my lord, petitioner is in trouble, my lord, because of the tendency of
Petitioner is in trouble? What trouble?
because my lord, because of
You,
the
if the petitioner was in trouble here. Okay. The instant petition has been filed challenging the orders passed by the Board of Revenue.
Yes.
Record is it? Record.
yes, my lord. Notice not served, that's why. And also, my lord, there is no failed verification report.
I'm not on that. I'm on the question as to whether on this date a judgment was there. 7. Advocate for the council present on behalf of senior advocate H.K. Deka. He had given a submission. Senior advocate is not able to appear as he is advised not to come to COVID. The counsel who appeared, Mr. Enchoti, gave an application and has not filed his wakalatnama. He is asked to file his wakalatnama by the end of the day if his petition for adjournment is to be accepted. The counsel who appeared also agreed to plead the case. Respondent also not appeared without notice government present last day. Fixing later on respondent number so and so appeared. Fixing as before. Appellant absent to last date was given for submission of the case. Government advocate present. Government advocate said that the case was being. So you were very much, you knew about this thing. Your lawyer was very much present.
He knew everything, my lord.
Then
But hearing that, he could not be appear, my lord, because of the date properly, my lord, informed by the office bearer, my lord. Supposed to inform by the officer, my lord, office bearer of the revenue board.
Where?
Not informed.
Where
The
is it?
revenue board, my lord. During hearing time, my lord. Can you perusal of the last order before to order, my lord?
I've seen that. That is the order of 1711. It does not say so. It says that your lawyer was Mr. H.K. Deka was supposed to appear. He did not appear. Then the other lawyer had submitted an application that he moved for adjournment. That adjournment was the court said the board said that you have to file a wakalatnama. Then also here and they were giving a last chance on 22/12. Are you saying that these orders are manipulated?
No, no, no.
Then
Not manipulated.
Then
But
what
my
is wrong?
only, my lord, prayer is that he has to hear, my lord.
He was very much present. Your person was very much present then. And it was not dismissed for default. Government advocate said that the appellant has been absent without steps and is a wastage of court's time. Counsel for the respondent pleasant pleaded that he may be heard. This is accepted. Post brief is that the appellant prepared the appeal against an order of the ADC so and so, heard, respondent argued in detail and so and so. So why should we? Okay.
I'll check, my lord.
Huh?
I will check the record, my lord.
What is there to see?
Just my
Huh?
one date may be given, my lord. I'll
Your advocate, he has filed the wakalatnama on 17/11/2020. Today is the date fixed for it. The engaged counsel HK Dekas is going old age, is unable to be present himself because of so and so. Application is filed. It is therefore prayed that your honor may be pleased to adjourn the matter for the day and fix another day. So the appellant has filed an application. Why are you making this type of statements?
22/12 only date.
Not on 22/12, on 17/11/2020. On that day, it has been this particular thing is there. Then
Then I have to check the records, my lord.
what is there to check? I have already checked it. You have
Sometimes
only
when I
to
check-
withdraw. You are only to withdraw today and say that I am sorry
I am sorry, my
for
lord.
making
Actually,
me misleading the court.
not actually not.
Then
Intention is not to mislead the court, actually, my lord. But
Huh?
on the basis of the submission from the, my lord, record and from the client, my lord, I have raised the case, my lord.
Because here you see this.
Yes.
No, this type of submission. Or file a proceedings before the bar council against this advocate. The next option level. That is the document which I have referred to. Isn't that a petition on behalf of the appellant? At the request of the learned counsel for the petitioner, matter stands adjourned to be listed after the winter vacations. No further adjournment shall be granted to the petitioner.
Much more.
Yes, enough. Hey, why you taking a photograph?
This petition.
No, Mr. Das.
Yeah, I'll deal.
Mr. Das, this is not done.
Yes, my lord, I'll deal.
This court had given you the liberty of looking into the record. Does it mean that you are going to take a photograph?
Sorry, my lord.
Why shouldn't I now
have
draw
deleted.
contempt against you? Tell me. No, Mr. Das.
I have deleted, my lord.
No, not deleted. I am now drawing contempt against you. You shouldn't have done that. Why have you taken a photograph?
But,
Why have you taken a photograph? You are supposed to, at best, you could have taken a certified copy of
yeah,
this.
applies for certificate copy.
No. Why have you taken the photograph?
My lord, suppose
I
to-
think
sorry,
now
I'm sorry, my lord.
I'll refer your case to the bar council.
I'm sorry, my lord.
No. This is a serious case, what you have done. It is in front of my eyes, this is done. You
I'm
have
sorry,
done.
my lord.
No. I think your license now has to be suspended for a period of 2 months, and thereafter your bar council proceedings has to be.
Sorry, my lord, wrongly, my lord.
No wrongly. You have in front of my eyes you have done.
Yes, my lord, I have done it, my lord, but actually I'm supposed to ask about the application, my lord.
What?
Supposed to ask about the application.
First of all, you have made the wrong submission before this court. Okay. Now, when I see it from the records that this is different, thereafter, what you do is, I give you the records to look into that document, you take a photograph.
I'm sorry, my lord, I have deleted, my lord.
Huh?
I'll never do in the future, my lord.
No. Are you taking this court for a joke?
No, my lord.
Then I think now you need a lawyer. First, you tell me how Board of Revenue works. The Board of Revenue officials keeps on intimating.
But this note was given to me, my lord.
Don't come with these notes.
The learned person who was conducting the case before.
Don't tell me all these things. Who has done what? I practiced the law time in the Board of Revenue. I know how it works. There's even a list which is being published. Isn't it, Mr. Ella?
Yes,
There?
showing the date of
And you
hearing.
are telling me all these things. I'm not taking up any action today. Black book or black book. But you have earlier one, today is second. The third time you are in more trouble. I mean, we're going to report it. This time I'm not doing it. Next time be careful.
Sorry, madam. I'm extremely sorry. I'll not.
No. There's no sorry business out here. This is a very serious thing which we have done. Next time you are in very, very thin ice. Mr. Das, don't take this code for granted. It is not such an easy thing. Yes, Mr. Chaudhary. I think, Mr. Chaudhary, you should have something and tell these type of lawyers how to act in the court.
That was improper.
With trust, I have given him the report. And he was taking a photograph.
But I am witness to the.
He shouldn't have done this. Yes,
The
Mr.
matter has been listed because of an order passed by the division bench. That must be on record, my lord. Order in Retail 335 of 2022. Order dated 14/12/20. Okay.
Yes. So I think the matter required to be heard.
Yes.
Lordship,
But then, my lord, but then must be find a complaint. There have been many other litigations between the parties, my lord. And after this, before this order, my lord, there was another order by which the petitioner has been settled with the my lord private response. And that is also under challenge.
Which order you have challenged here?
Here in this,
There's some order you went to the division bench. Which one is it?
my lord, this was the order that was challenged.
It was a disposal.
Lordship, it is a dispose of case, Lordship, and the honorable division bench has also disposed of the appeal also, Lordship. But because, Lordship, there has been a slight typographical mistake in the WPC number, that has been listed again, Lordship. The matter has been revised. And also we have preferred a review, Lordship, regarding the error, Lordship.
First thing, my lord, there is no typographical error as such.
No, Lordship, there is
And this writ appeal is 335. Writ appeal preferred against my lord, the judgment in 1441 of 2022. And they have filed a review against this order in May 2022. And it
But Mr. Chaudhary, tell me one thing. Without setting aside this judgment by the division bench, how can they remand this matter back? Huh?
So in fact, my lord, the orders are a little, I'll say, my lord, little clumsy. That's why, my lord, my prayer would be, let this matter be checked with another petition, because they are saying that that petition has to be heard. Both the matters may be listed together.
Because this is a very difficult situation the single judge is in. Because the court and bench have already decided this.
Right.
You have been asked to raise all these points, but without setting aside this judgment. If you don't set aside, am I not bound? They should have written one line that we are set aside.
Can it come along with the other petition?
Is the matter along with
WPC 7584. of 2022.
7522 of 2022
22.
after the winter vacation. This court also is of the opinion that taking into account that the matter has already been dealt with by a coordinate bench and there was a judgment and order dated 30/9/2022 which was passed, by which the petition was disposed of. The matter be laid before the said bench by the registrar. I think better off let him take a call. It becomes very difficult for this court to have any other opinion without that be setting aside.
32.
Yes.
Matter relates to my transmission line compensation.
Huh?
Transmission line compensation.
Okay.
The transmission line under Assam Electricity Grid Corporation.
What do you want? Some representation you have submitted or what?
Matter was adjudicated and upon, and thereafter bill was also issued and subsequent check was also issued. But the revenue authority is saying that some public complaint against the petitioner, so he is not entitled. On that basis, check is not handing over to the petitioner.
1,96,000.
Yes.
You are entitled to.
Yes, my lord. Page 15.
You are entitled to from whom?
Electricity Grid Corporation.
Yes, Mr. Kutuk.
We have issued the stake, we have circular officer returned it. On the ground that there are some complaint against the petitioner.
For what?
I don't know, that could be, that can be.
Yes, circle officer. What is it?
That instruction I don't have, but my lord, we have filed one affidavit on 26th of April 23, lordship. There we have
Affidavit filed by?
filed by, my lord, deputy, by the assistant commissioner.
Assistant Commissioner.
In that, my lord, in paragraph 9, page 30.
So here you are saying that the petitioner is not entitled to
Lordship,
that amount.
Lordship, they could not found him in the land, my lord. They're not found under possession of the petitioner.
So they are relying upon Manipur circle officer report.
You have filed a reply?
Yes, sir.
They have filed, my lord.
Then?
To reply.
Hello, we do one thing. We'll have it after the vacation, fix a date.
My lord, I'll also take instruction on the some, my lord, we have.
Yes.
And plus some.
List the matter again after the vacation on 23rd of January 2024, on which date an attempt shall be made to dispose of the petition.
May I have prayer, my lord, along with my lord, writ petition number 36.
That matter is before this court.
No, sorry, my lord. Sorry.
33.
Hmm.
My lord, the petitioner, my lord, is application for permanent court of land matter, and he submitted proposal for land settlement, my lord. And the state land advisory committee, my lord, approved his, my lord, proposal for allotment, my lord. Later, lordship will find an extra 7, my lord,
So the land is government land.
permanent land.
Are you in possession?
Yes, my lord.
How much?
My lord, about my lord, 15 lessa, my lord.
Huh?
15 lessa.
15 lechas. You are in possession. Why are both petitioners different?
Of course, they're different. My lord, petitioner number 2 actually, he's a resident of the same locality.
So why are you making the petitioner number 2 a party?
Petitioner number 2 also has the same grievance.
Regarding?
Regarding that, they were supposed to be evicted, and they also filed application for allotment of land.
How much land?
Allotment of 15 lessers.
Where is the land?
My lord, land, it is, my lord, not looking for town, tax number 688. Revenue, not looking for town, first part, revenue.
Are you-
Moja.
But this land cannot be granted in view of the specific statement.
My lord, and my lord, land is, my lord, more than 15 letters. Land, my lord, is in position of petitioner number is more than 15 letters.
No, 15 of 1 kata, 2 kata hardly matters because of the fact that this land cannot be settled with you.
Lordship.
Your settlement application can be taken for some other settlement period, but not for this.
My lord,
When did you file your application for settlement?
My lord, maybe in 2000, or
Huh?
2000, my lord, 4.
2004 would not do.
2004.
Now, as per the new land policy, you have to apply. Where have you made the application? Show me.
My lord, based on my application, my lord, my lord, my country annexure 5, my lord, page 34, my lord. Based on my application, my lord, they made some communication.
That doesn't give you a right.
And my lord, one thing, my lord, annexure 6, my lord. My lord, my country annexure 6, page 38.
Hmm?
Page 38.
You are asked to submit proposal of the land mentioned in the application of a court inquiry.
My lord, here, my lord,
That is of 2004. And what about the other one?
my lord, page number 38, annexure 6. my
Page
lord.
number?
38, annexure 6, my lord. My name is, here's a serial number 3, my lord.
No, that is what I have seen. Page 34.
38.
Page 34 is the type copy of 36.
My page 38 is the my lord, proposal that it has been shown as approved, my lord.
By the
My lord, land advisory committee, seal of additional deputy commissioner of Lakhimpur Jam.
where is the name?
My lord,
Unakit Tayang. Taye. And the other one is
my lord.
the second petitioner is
The second petitioner's name is not there, my lord.
that. Why you are bringing her?
No, no, my lord, because my lord, on 3/10/2021, the respondent sought to evict both of them from the state court of law.
So?
That is why while this
The 3/10/2021, the respondent may take all the 100 petitioners. So would you the persons would you bring everybody out here? Everybody will have a separate cause of action. Then what to do?
yeah,
Court fee also one person.
at the point of where from that
This is the matter of the vacation. There's an interim order.
Yes, ma'am.
We vacate it.
Same order was passed. Yes, but
No, interim order was not extended. There's no interim order. Interim order has gone after 2022. Where is the interim order?
well, they
Till the name, no coercive action will be taken against the petitioner, one petition. However, it is clear that the order passed without instructions being obtained by the AR may not be modification. Till to ensure the interim order extends. This court, upon hearing the learned counsels for the parties and also perusing the affidavit in opposition, is of the opinion that the petitioners herein cannot be settled with the land under their occupation, taking into account the present land policy of 2019. Under such circumstances, the question of granting issuance of a writ of a mandamus directing the respondent authorities to grant settlement in respect to the land presently in occupation of the petitioner, that is in dark number, which dark number?
688.
688 of village North Lakhimpur town part 4, Moza Lakhimpur in the district of Lakhimpur, Assam, cannot be issued, as the same would go against the land policy of 2019. And more so when the said land policy of 2019 is not the subject matter of challenge. The record further reveals that the interim order which was passed initially have also not been extended. This court, however, grants the liberty to the petitioners to file appropriate application within a period of 30 days from today, in terms with the land policy of 2019. And in the circumstance such application is filed within the period above mentioned, within the periods allowed, the respondent authority shall duly consider the said application. It is further directed that in the circumstance the said applications are filed within the period of 30 days as stated as above noted. The possession of the petitioner should not be disturbed till the disposal of the said application. With the above, the petition stands disposed.
Right.
No, the possession, no. The status quo of as on today be maintained, because you may have been thrown out. The status quo as on today be maintained in respect to the land.
Lordship, okay. May I plead your lordship?
Yes, madam.
This is I appear for private respondent. I pray some time to file affidavit in opposition.
Right, the 2021 matter you have judged now. What is this matter about? Yes. What is your matter?
Petitioner school is paying demarcation of the part land.
Directing the respondent number 2 to dismantle the bamboo wall erected by the private respondent upon the petitioner's school and hand over the possession of the encroached land. Okay. And who are you? Government?
School, my lord.
No, are you a government?
Yeah.
Are you a government school?
Yes, my lord.
Huh?
Government.
Then why are you approaching this court? If there is some person creating some problem out there, that is for them. If the private respondent is there encroaching upon your land, isn't it for the civil court to decide? Then what is this court going to do?
This is my.
You want this court to direct these respondent authorities to take the law in their own hands?
So this is the second round of litigation.
Maybe second, if you keep on filing like this type of writ petitions, it will maybe the sixth round also. Then, yes, madam, why do you need to file affidavit in these type of matters?
Yes, Lordship. In fact, Lordship, demarcation has already done, Lordship.
Then,
After demarcation, they again have.
so if you have any problem, you go before the civil court.
In fact, perhaps some civil suit is also going on. That is
Huh?
why, perhaps some civil suit is going on between the parties. That is my telephone
And-
instruction, Lordship.
So you want an additional advantage of an order passed by this court. Therefore, this court, no, upon hearing the learned counsels appearing on behalf of the parties and taking into account the facts involved wherein the petitioner complains about the alleged encroachment made by the respondent, private respondent, to the land of the petitioner, it is the opinion of this court that the same amounts to a private dispute between the petitioner and the private respondent. Pertaining to the rights over the land in question. Under such circumstances, this court is not inclined to entertain the instant writ petition. Be that as it may, the petitioner herein would be at liberty to approach the appropriate forum or the competent civil court for redressal of the grievances, if so advised. With the above, the petition stands disposed.
Obliged.
49.
Please,
We have applied for RTI, but reply has not yet been received. 32 is that many.
please, your lordship. My senior is not available in the court now.
Your senior is,
Mr. Astikal,
where is he?
he is not in the court
Should
Due to
this
some
court
pers-
go there?
due to some personal inconvenience.
Who is this the matter, that one?
Yes.
What happened?
Lordship,
With reference to the subject, I would like to inform you that the below mentioned 4 number has been deposited to the government in relation to the period dated so and so. Request you to provide me the information as to which period the aforementioned challan amounts have been adjusted. I'm sure that I have paid the challans amounted related to so and so. This was given on 1812, knowing fully well the matter is fixed on 1912. Because on 1411, you say that you are going to take steps under the Right to Information Act. Very careful. Chalo. Is there any stay? The learned counsel appearing on behalf of the petitioner seeks for some accommodation in the matter. List the matter after 4 weeks.
Much obliged.
There's no interim order. Wait.
Much obliged.
My lord,
Yes,
it's the conditional order was there, my
some
lord.
cost is there.
I have already submitted.
Very good.
Is there, if
I accrued upon the, however, the same was
Yeah,
duly
yeah.
taken care of by imposing accordingly,
Already
so and so only is imposed upon the petitioner which shall be positive. What is this matter about? Restoration. Oh, dismissal. Yeah, tell me. Okay. Now what is there?
or actually, duty speaking, my lord, another similar matter was in the nature.
So we restored it, no?
Restored it. At that time,
And
I
then
made it
thereupon, Now this will be fixed for what? Admission.
Maybe pick their orders because why? Because one similar matter has been dismissed by the Honorable Court. I could not procure that order.
Dismissed?
Another matter, similar matter, truly speaking. It is why next after vacation it will be listed because today
But the
What is
problem
the
arises
order
out
been
here.
issued?
Who is paying for the respondents?
Suppose that Mr. Government also.
The government is okay, but the main
Mr.
problem is you are challenging a
okay.
Board of Revenue's order. Are their names shown? Who is paying for the respondents in the list? I think we have to, you are paying for the private respondent?
Number 227, Lord.
Okay.
This
So then it is okay. We'll fix it for admission. Was it admitted at any point of time?
No, Lordship, and similar matter has already been disposed of, Lordship,
By
Justice Manish Chaudhary, Lordship. Similar part, same cause of action, everything same.
Not maybe take after vacation.
Huh?
I also submitted very beginning.
This may be fixed.
Maybe take
so we dismiss it right away.
if because I do not have so now presently that order my learned engineer is failed to bring that order.
This is pertaining to the same matter.
Same matter, Lordship.
Issue involving same.
Issue is same.
Against the same order, I thought. Huh? Oh, you were there.
I was a bit there.
Ah,
They have
common
not paid.
judgment.
Oh, 100.
Instant petition, you are challenging the order dated 1/11.
Not I pay only same order. You're not after vacation because
Why?
because I have also to dismissal also I have to that order.
No. First of all, you appeared in that matter.
Right.
That matter before Justice Chaudhary.
Oh yes. Yeah, that is right.
So
Honestly
you know
speaking,
about this order.
Honestly speaking, I have submitted very beginning without.
Therefore, we close it. I think the best is to file an appeal as soon as possible. The instant petition, it has been submitted at the bar by the learned counsel appearing on behalf of parties that the dispute involved in the instant petition is squarely covered by the judgment of this coordinate bench delivered on 3/8/2023 in WPC number 4622/2012. Whereby the coordinate bench of this court did not find any infirmity in the impugned judgment dated 1/11/2010 passed in the three revenue appeals, that is case number 151 RA bracket DIB bracket close oblique 2006 Roman 2 number 2, case number 152 RA bracket DIB oblique 2006, and number 3, case number 153 RA bracket DIB oblique 2006, as well as the orders dated 21/8/2006 passed in the three mutation appeals, being number 1, mutation appeal number DRP 18/2006, number 2, mutation appeal number DRP 19/2006, and number 3, mutation appeal number DRP 20/2006. So Mr. S.C. Bolwa, the learned counsel appearing on behalf of the petitioner, had submitted that the state judgment that this court needs to take a different view in the matter, but this court, upon hearing the counsel, is of the opinion that this court finds no reason to differ with the opinion rendered by the coordinate bench. So accordingly, the instant writ petition, therefore, is being squarely covered with the judgment dated 3/8/2023, passed in WPC number 4622/2016. The instant writ petition also stands dismissed. I've made that submission so that you can file appeal.
Right.
Madam, you give your name. Yes, who is appearing for everybody?
Lordship, I'm appearing for respondent 1 to 5.
What about the respondent, other respondents, 6 to 9, presumed?
So for office notice, concern, my lord, that is complete.
5 to 9? No, that's right. Okay, so service is complete. Service being complete leaves the matter for admission immediately after the winter vacations.
Thirty-nine.
38. Yes, what is this?
Lordship, in this case, Lordship, respondent number 3 had died, Lordship.
Learned counsel appearing on behalf of submits that as a and expired, which is apparent on the law record, would take appropriate steps. Then what happened?
I will file substitution petition, Lordship.
Have you filed?
No, Lordship.
Yeah?
Need some time, Lordship.
That is long, 3 months back. You have not filed.
No,
Lozima court order is 14/9. Okay.
can I fix after vacation, Lordship? I will file.
Petitioner also died
Yes, Lordship.
in 2019. You have not done anything. Huh? Have you done anything? Oh, you have filed some application. No. Now, in the meantime, respondent also died.
Yes.
And this application has nothing been done. No?
No, no.
Yes, Mr. Barpujari. What to do? Petitioner died in 2016. In 2021, they filed application for the purpose of substitution.
But not
In
for
the meantime, the other person has also died. Now they have not taken any action against them.
both ways abated.
What to do?
there is no application for setting aside abatement, then my lord, automatically by a person of law it will abate. They will have to file an application at least for setting aside abatement.
Okay. Taking into account the order, taking into account the office note dated 29/11/2023, the matter stands adjourned to be listed after 4 weeks. No use. Coming. Okay,
Matpa. Which was after effective decision lordship, it was ordered to be shifted to Godchuk Lord, Amos, wholesale market. So it was shifted and accordingly the petitioner, present petitioner, they were running their wholesale business at Matko. Then they shifted to Pamohi Lord. Thereafter, the government has constructed the RCC building as well as some type of house. And that market was meant only for the wholesaler, not for the retailer. Then thereafter, what the official respondent did lordship on the road lordship and on the footpath, which is meant only for easing as an ingress and egress of the customers and the wholesaler businessman lordship. They had constructed a temporary structure and letting out to the retailers lordship area without having any valid agreement or without paying the proper fees lordship. So this writ petition has been filed. Lordship may please to peruse the page 78 lordship of the 78 of writ petition lordship, which will show that unauthorized construction done by the official respondent lordship that has tubular pipes and the tin set lordship over the road and footpath. And even lordship, the now due to unauthorized construction lordship, the heavy truck cannot enter, they cannot turn their vehicles. These are the difficulty faced by the hospital.
yes, Mr. Gogoi.
Lordship, the allegation of the petition is really false, Lordship. The couriers are doing the business from the date of inception of the market.
Who?
The
Other people.
Other people. From the
Other
date of-
people are before this court.
No, Lord.
Yes.
What happened, Lordship? There is a PL was filed by some on that case. We are not the party on the PIL, the marketing board. Already we have a market in the Pamuhi Lordship, the present market. We started the market along with the 4 years Lordship. After the judgment of the Honorable Apex Court, the court directed that to accommodate the evicted wholesalers to other outside the city lordship. Accordingly, the list was prepared by the GMC lordship, and the present petitioners to accommodate. That is the case, Lord.
You have been accommodated.
Yes, lordship.
Yes.
They
Then what
already
do you want?
accommodated.
Lordship, they had constructed unauthorized
Lordship, it is-
construction. The heavy vehicle
Lordship.
cannot take turn back the vehicles, Lordship, and even the electricity board APDCL had requested the market committee to shift the electrical wire which has been passed through the gate, nearing it, and causing serious threat to the lives of the wholesalers as well as the customers.
That is not your subject matter of your petition.
Yes, yes, I have filed.
Your subject matter of the petition is directing, commanding the respondents not to give, allot, and hand over the possession of those sheds to unauthorized vegetable and food vendors or other unauthorized traders, and further the respondents may be directed not to allow any unauthorized illegal fruit and vegetable vendors or other unauthorized traders. What is the basis of you are saying them to be unauthorized?
They are not having any license. They were given temporary licenses, Lordship, only up to 2016. Thereafter, no.
You have a permanent license.
No. We are having agreement with the market. One copy I have annexed to the.
What agreement?
Lordship, as on date,
Tenancy
Lordship, what happened, Lordship? I will clarify,
Tenancy
Lordship.
agreement.
What is the agreement?
Rent agreement, page 67.
Guwahati Sub-Divisional Market Committee.
That is the agreement, Lordship, after the allotment, Lordship, after the accommodation.
Yes, sir. After the allotment,
Only for
Lordship,
1 year, that is for
the
only 1 year.
marketing board had entered into various agreements. As one of the model agreement, I have annexed, Lordship. This is dated 15 November 2017. Monthly tenant.
Then
Then, Lordship, the
this
official
tenancy agreement was valid for what time? What period?
it provides, Lordship, Lordship may come to page 68 per hour.
Hmm.
That in consideration of the grant herein after reserve and on the other conditions herein contained, the lessor agrees to let out. The lessee agrees to take on lease the land covenant and the premises identified of number so and so on first floor fixtures and fittings standing thereon herein after called the soap premises, more particularly described in the schedule A for the purpose of running the business. Prior to the soap premises shall be deemed to be include the fixtures and fittings existing thereon shown in the A above and the lessee shall
Clause 6.
clause 6.
6 and 7.
Clause 6, the tenancy will commence on and from the date of signing execution of this tenancy agreement, the 15th day of November 2017, and shall, subject to the terms thereof, continue for a term of 11 months with an option to the licensee to renew the tenancy for a further term as set out in clause 7 thereof.
And
So they are renewing it, they are accepting the rent, we are paying the rent regularly, we have not defaulted it. Our grievance is, Lordship, the retailer, Lordship, this market is mean as per the apex court decision.
no, but Mr. Roy, tell me, how can this court pass any order that those persons are here? How do this court pass an order to that effect? Unless you identify those persons.
They have been identified, the respondents have
Then
filed
if they are identified, they should be made parties. Do these people not have a right to hear?
but the
You have
official,
not done that.
the official respondent, Lordship, they had given the reply that they are allowed and
But let us take the chance like this, where you are saying on one hand, if I pass an order not to do that,
yes, of
wouldn't I
course,
be passing an order against them without hearing
yes,
them?
I may be allowed to implement. They have given the list of the retail.
Oh, very well, you have it.
Also, as on that, they have no any license. Also. From 2016, we closed to issue the stop the issuing of license. Also. I had ordered it, Lordship, 23 to 23, they're supposed to give a affidavit in this regard that they have valid license on that day as a order loss. But they have not filed any
There is,
affidavit in this
Lordship,
regard.
automatic renewal.
No, there is no automatic renewal, Lordship.
Lordship, there is a clause for the renewal of
No,
11 months period. And
So,
there-
That
have
is
you
a
have you
disagreement.
have you gone for renewal?
No,
they
they
are
have
not
not even-
doing. They are accepting the.
No, that is a different cause of action. Then
Then they will statutory return in, Lordship after expiry as per the Rent Control Act.
at the request of the Mr. Roy, if it is for rent control act, go before the civil courts. This is not for this court to decide.
No, I have not come for against the eviction.
Then you have, first you have to establish your right to get an injunction, to get an order out here, which
Lordship, my
order you
only
are asking
grievance
for.
is that areas are not entitled to do marketing in the.
I can
wholesale
do one
market.
thing. I can close the writ petition giving you the liberty, go there. This is not the forum by which you are going to. First, you have to establish your right. He says that you don't have a right. How can this court now construe that there is a right? And on the basis of that right, only the consequential action will follow, which you are asking out here. He says that where is his edifice is not there. Where is the question of passing any order?
Allow me to implement.
Huh?
I'll implement it. Their names, addresses have been.
Okay. Mr. S.P. Roy, the learned counsel appearing on behalf of the petitioner, submits that he has the list available of the persons whom the petitioner alleges as unauthorized traders and he would like take appropriate steps for implementing them to the instant writ proceedings. So taking into account the above, the instant writ petition, taking into account the said submission, the instant writ petition therefore stands adjourned to be listed in the second week of February 2024. Full stop. What is this? I close it. We'll close this. Something has to be done today. So taking into account the above submission, Mr. S.P. Roy, the learned counsel appearing on behalf of the petitioner, submits that he would not like to press the instant interlocutor. Okay, okay. Then I dismiss it on merits. The instant application.
I have to, because they will be pleaded in the IA also.
No, but the same prayer is there in that petition also.
Same prayer.
It is the same interim prayer is there here, both. And in there also no order was passed. Now here also no order has been passed.
It can be considered after implementation.
But there the prayer is still there. Interim prayer is, have you seen the interim prayer? Isn't it the both same? The instant application has been filed by the petitioner.
In that event, I may be allowed to withdraw it.
Withdraw it. The learned counsel appearing on behalf of the petitioner submits that for the present, he would not like to press the instant interlocutory application, taking into account the specific stand taken by the Assam Agricultural Marketing Board. Taking into account the above, the instant application stands closed on withdrawal.
Also in the order can be recorded unauthorized status in ticket 4 years.
Huh?
In 4 years, they are in as per act, they are the 4 years. Okay.
He says that unauthorized status.
And 5 years.
4 years.
Retailer. Lot if the today comes
Give
some other
the spelling name. Next.
40.
Oh, this one.
Yes.
Tell me.
After exercising due diligence, some documents could not be brought to the notice of this honorable court at the time of hearing.
Then?
So these documents are before the honorable court now.
Huh?
So those documents are before this honorable court, my lord, now. Page 38 onward.
Yes.
Some documents, my lord, which were issued by the officer in charge range, Kaki range, my lord, in 2019, my lord, 58 onward. So, my lord, from these documents, it is very much clear that, my lord, petitioners are residing in the my lord, reserve forest area.
Huh?
My lord, lead person was dismissed on the ground that, my lord. Can you skip page 124, my lord?
No, first of all, when you have not, why should I reopen this?
My lord.
Where were these documents all along?
Yes, my lord. These are, my lord.
No. Prove those original. Produce all the original documents before this court.
Yes, my lord. I'll produce on the next step.
And why you have not produced these documents earlier? From where? From where did you find out?
My lord,
Most interesting in his petition, one part, my lord, they say different story. Only one part relates to the dispute we are dealing with, land part. And one part is okay. The grandfather was there. In fact, the grandfather's name is some Gwala, and the petitioners are Yadav.
And grandfather of the petitioner.
They changed the name.
No,
They didn't like the title.
My lord, Yadav generally.
Huh? Yadav and Gwala is same.
Yes, same.
And then, my lord, only from para 7, it deals with the land which is in under scrutiny here, man. Only from paragraph 7 of the petition. Other story, that's a different.
The issue here is, my lord, before report, my lord. Page 124, my lord, paragraph 26, my lord. By saying that by that, my lord, the petition was dismissed. Only because, my lord, the petitioner
are not resi-
Annexure
residing
E and E1, let us see where is annexure E and E1.
my lord.
ENE what?
Annexure E and E1. What is this? It's a registered gift.
No, my lord.
Then why should this
That is
court
their-
look into
that-
those?
That is their meaning.
Then
Even my lord, but they are residing in the forest land, my lord, for last 3 generations. That is
you are still residing.
yes, my lord, still.
You reside, be happy. They are not going to give you the allotment. How can this allotment be given of forest land?
No, my lord.
Impossible.
That is my lord, as per provision of my lord.
That 2016,
Yes, my
2000, you are not a forest developer.
lord. Other traditional forest development.
Oh, okay. You have no document, nothing there till 2000, that 1998 or 97.
My lord, these documents were there, my lord, but after exercising due diligence,
What
my
is
lord,
this
defense
due
could not-
diligence?
Could not brought that these documents before from the court at the time of hearing, my lord.
We do one thing. I'm asking him to produce the original.
Yes, my lord.
Let us see.
Yes, yes. On the next day, my lord.
When? Produce the originals of those documents.
Yes, in the month of February.
And where did you find out these documents?
My lord, page 38 on
Huh?
my lord.
How did you find out these documents?
Just after before filing of this case,
How?
I contact my client to
These are not disputed, my lord.
Huh?
Till paragraph 6, these are there, substantiated. But land in question starts from paragraph 7. The Cheru, they brought it from a person called two brothers. That is under dispute, my lord. They're claiming right over that land, which cannot be, my lord, alienated by deed,
By the gift deed.
by gift deed.
my lord, I will bring the
That will
original
bring-
document.
Now,
Original-
how did you get these documents? Where this matter was pending from 2005.
Yes, my lord.
Then
My lord, after exercising
why you are not
due
filing an appeal?
it could not be, my lord, brought.
Huh?
After exercising due diligence, my lord.
What is this due diligence?
Yes, sir,
You
there-
could
there,
not
my
find
lord,
out for the last 10, 11 years. Now you have got found out. After dismissal of the writ petition.
my lord. It is
The learned counsel appearing on behalf of the petitioner is directed to produce the originals of the documents which have been placed before this court and also file an affidavit categorically stating as to how the said documents was traced pursuant to the delivery of the judgment sought to be reviewed. List the matter again on 12th of February 2024.
published. What you want?
Make clear one. All of the matter relates to an order passed by the special tribunal in landscaping case. And my lord, the matter has come up for orders today in view of the fact that my lord,
The
filed an
applicant reduced
application
further
I
evidence and place the
for
document on the
editing
petition
additional
record keeping para. What is this? This is an application for additional evidence before this court.
My lord, in fact, an appeal lies against the order of the my lord, the tribunal, special tribunal, but the appellate forum has not been constituted.
So you're doing under 227. Then
It is 226 a lot.
Huh?
226.
226.
Hmm.
Because,
and how will the 226 lie?
because my lord, I don't have any alternative other remedy. I don't have the remedy that
But isn't that an order being passed by the authority? But anyways, we can convert this 226 to 227. That is not the issue. But Where is the order?
The order of the special tribunal is at page 61.
Oh, I can't take up this matter. Okay, list the matter before any other. No, these affidavits which are being filed out here, na? And I know this person very well. Won't be proper. List the matter before any other court.
Lordship, about 226, Lordship, that
Hmm?
this petition is maintainable, Your Lordship. On that, Your Lordship, we took.
No, Mr. Ali, I am not taking up the matter. Taking into account the respondent who has filed the affidavit, I know him very well. So this is, therefore I have asked the matter to be listed before any other bench.
Can it be fixed, Your Lordship?
List the matter before any other bench in the second week of January.
That is a lot. My lord, I am appearing for the respondent railways in this matter.
Hmm.
Now, this is an application for restoration.
Hmm.
My lord, this application, the order was passed on dismissing the case 38/2022. And this application for restoration was filed on 22nd of November 2023. But interestingly, Lordship, the affidavit was on sometime in May, but this was filed in November, and Lordship may come to the first page, even the Chief Justice's name has not been corrected. I don't know whether your Lordship will be entertaining this or posting any orders on this. When this application was filed on 22nd of November, Honorable Chief Justice was already elevated to Supreme Court. So this petition in the present form,
Won't make it.
and otherwise, my lord,
Mr. Chakravarti, these smaller things need not detain.
I just pointing out, my lord.
What is there in the name, Mr. Chakravarti? A rose is always a rose.
That is true, my lord.
Then
That is true.
none appears on behalf of the applicant on call. Who lists the matter after, lists the matter again on 22nd of January 2024.
Can it be on some other 22nd? I will not be able.
On 19th of January 2024, it is made clear if the respondent petitioner applicant is not represented, the instant application shall be dismissed for non-prosecution.
I am appearing for railways.
Give your names out there. Don't put the name.
May it please the Lordship.
Hmm.
I seek accommodation today, Lordship. I was in discourse and couldn't brief my senior, Mr. K. and Chaudhary, leading the case, Lordship. I couldn't brief my senior, Mr. K. and Chaudhary, who is leading in the matter, Lordship.
So,
I
why do you need a senior for this?
matter being no, because
Admit the petition upon hearing the concern and be pleased to direct the respondent to grant waiver as paid by the order needed under the scheme announced the one which was applied for in the year 2000 against the instead of the amnesty scheme. What is this?
there are two amnesty schemes, Lordship. We had applied for one in 2019. It is a bamboo manufacturing unit, Lordship. And we had applied in 2019, but later on we were given an offer of another scheme recently, which does not suit our requirements, Lordship, because the other one we had applied for was to our, it suited us more. So we are praying that the second one, instead of the second one, the first one we prayed for in 2019 be granted to us, Lordship. And the matter may be disposed of after a hearing, which may be fixed anytime in the first week, maybe on or second week of January. Second, 9th or 9th or 11th, not sure. the amnesty offer, the advertisement is on page 21.
Hmm.
That is the
No,
one we,
understood, but don't you think that this comes within the ambit of what you are asking in the IA is completely different from what is there in the petition?
Lordship, because there itself we were praying for a waiver, Lordship, considering the
Understood.
amount of
If it is
work-
waiver you are asking for, why are you mentioning about this amnesty thing?
because there is a via media, there was some kind of settlement going on, Lordship, between the parties. And there the matter came up that it may be settled by way of the amnesty given later. But now we had already sought one in 2019, which was not disposed of. So we were craving indulgence that may be disposed of, and if we are given that concession, then it would be suitable for us.
Okay, then we issue notice
Yes.
about this IA to him and get their instructions on this.
Yes, but
Okay. The instant application has been filed by the petitioner. Seeking a direction upon the respondent number 4. That is the Directorate General of Foreign Trade, DGFT, to grant waiver as prayed for by letter dated 27/2023 under the scheme announced by notification number 1071/4/2019-CX.8 dated 27/8/2019, which was applied for in 2019 instead of the amnesty scheme notified on 1/4/2023. Issue notice, Miss So-and-so, Miss A. Bhuya, Gayan, appears on behalf of all the respondents.
No, my lord, reference number 125, 6 I'm not appearing, my lord.
Huh?
6 I'm not appearing for 6, my lord. SC girl is
Appears on behalf of the respondent number 1, 2, 3,
5 and my lord,
4, 5,
5, 8 and 10, my lord.
8, and 10.
Yes, my lord.
Good stuff. And who appears for 10, 8, and 9?
9, my lord. National Commission. Oh, yes, I am, my lord.
9 is
Under
9 and
Ministry of
10,
9
huh?
and- yes, my lord.
No, 7 also?
7, my lord.
7 also?
Yes,
If-
National Mission for People. Yes.
Appears for all the,
Except
all the respondents except
Respondent
respondent number
number
6.
and 11.
6 and
11.
11. Good stuff. The State Council, taking into account the directions which have been sought for by way of the instant application, the state respondent, more particularly the respondent number 4, shall file the affidavit as regards the entitlement of the petitioner as sought for in the instant application. So extra copies of the instant application be served upon her by 22/12/2023. As regards the respondent number 6 and 11, the petitioner is permitted to serve an extra copy to Mr. S.C. Kyle, the Standing Counsel of the Customs Department.
he had appeared and filed an affidavit in the earlier.
In main petition, not in IA.
No, not in.
IA.
This order is in the IA. In the and as regards to respondent number 11, is somebody appearing here for 11?
Didn't appear, no, not, but steps we have taken.
As regards to respondent number 11, the petitioner shall issue notice, shall take steps by registered as well as usual. আগতে issue notice করেছিল, making it returnable on 12th of February.
Deeply applied. Stop.
46. Yes.
Lordship, we have filed an I for bringing on court the there is
Who died?
the sole petition.
Hmm?
Sole petitioner.
Petitioner died.
Yes. 11/12.
The instant application has been filed by the petitioner, by the applicant. Bring it to the notice of the court that the petitioner expired during the pendency of the petition on 11/12/2021. And as such, as the applicants have applicants are the legal representatives of the petitioner, they be substituted to as the petitioner in the instant proceeding, in the accompanying writ proceeding. Taking into account the above, which has not been objected by the respondents, this court allows the substitution as sought for, thereby substituting the applicant numbers 1A, 1B, 1C, 1D against the petitioner. The petitioner is directed to file an amended memo of parties by 22/12/2023 before this registry of this court, and on the basis of the instant order as well as the memo of parties, the registry shall make necessary correction in the cause title of the petition and also update the same in the CIS. So here goes. List the matter. It has been admitted.
Yes.
You sure?
My lord, we have filed affidavit and they have filed also reply also. In this case, we have filed affidavit, my lord, and petitioner has also filed reply, my lord.
Who has filed affidavit?
TMC, my lord.
Huh?
TMC, my lord.
Where? Yes, I've seen it. Affidavit in opposition file, affidavit in reply file.
My lord.
I'm asking whether it has been admitted. No, it has not been
Not
admitted.
yet, my.
So stop. The main matter, here, list the matter for admission in the on 22nd of January.
Okay.
This order lists the matter for admission. I finished the matter before that.